appeal. Correct?
With the liberty to file
Liberty to file fresh.
a better application.
Can we do that? You have to find liberty. So how?
With liberty to come to the court afresh on the basis of very cause of action, very same cause of action. First, who is the opponent? Your opponent?
Yes.
First time it has come.
First time.
The appeal is at the preliminary stage and notice is yet to be issued. First now, right to file appeal includes right to withdraw the same, sometimes with liberty to refile it. First now, in the above circumstances, appeal is disposed of as having been withdrawn with liberty as sought for. Next.
Item 3, Writ Appeal 1717/2025.
Hello, dear Lordship, has disposed of another writ appeal. The same kind of
by speed for immediate.
similar kind of, your Lordship, dispose of the another writ appeal in case of similarly placed person. My Lordship, can you see? The documents are also same and the position is also same. The petitioner in that case is page 73, Lordship will find.
Have you shared a copy with
Yes, sir, already, sir.
Judgment.
Already, sir.
How many?
Only one petitioner here. Same document, same. The 73 serial 5, earlier petitioner, earlier respondent was there, and here in this case serial 14.
Identical.
Yes.
He was also to retire from that organization.
Yes. Exactly same, exactly same.
Any delay was booked in filing the appeal?
Delay. No, there is no delay.
30 days delay.
But IN
30 days delay. No, delay is no.
not the ordinary. IA is for
for appeal to stay of the loan. Stay of the loan. IA is for stay.
this intra-court appeal seeks to call in question a learned single judge's order dated 26/8/2025, whereby appellant's WPC number 22590
Yes.
of 2025 has been disposed of in the light of a cognate case in WPC number 22007 of 2025, virtually denying relief to the appellant. First, after service of notice, the respondent have entered appearance through learned AGA Srimati Samit Sismans. Very fairly, she does not dispute that the subject matter of this appeal is substantially similar to the one in writ appeal number 1717 of 2025,
1469.
1469 of 2025. Disposed of by us, wide order dated 20 April 2026. First, our order reverses impugned order of the learned single judge and confers the relief on the appellant in the following terms. This and put yellow that you have to 5.4 and 2. Okay, lab also just look into next paragraph. In the above circumstances, no difference having been demonstrated for further examination, comma, this appeal succeeds and relief granted in the cognate case is extended mutatis mutandis in favor of the appellant hearing.
Yeah, just,
Huh?
no.
Appellant
No,
hearing.
just supplement.
Appellant hearing. No cause. Duplicate.
Item 4, review petition 86 of 2026.
Audit of vacation.
One difficulty your lordship is that by virtue of the order date 24th of March, lordship directed us to file to deposit a sum of rupees 24 lakhs before the bank and remaining a few weeks after for the period of 2 weeks. Now what have happened, your lordship, is that your lordship, the first installment, your lordship directed us to pay 24 lakhs. But so far as the second installment is concerned, is no amount has been directed. So it is being
Second installment is how much?
has not been stated, your lordship.
My lords, it
Not
was
installed.
in open court, my lord said 48 lakhs in 2 installments.
Two installment.
Yes.
First installment is 24 lakh.
Take it. I mean, I'll see the order here,
Well,
of 5, your lordship.
It's
To the matter of the sometime in the no basis is able that the borrower and guarantors shall deposit the sum of the petitions within the 3 weeks and the balance amount within a further period of 2 weeks.
Yes, your lordship. The
That
balance
is
amount is
condition
not
for
clear.
consideration of the proposed
Yes, yes.
application for one time, that is OTS.
My lords.
Bank shall consider the said application.
My lords.
What is the amount, remaining amount?
Permit me.
You are for,
I am petitioner, writ petitioner here. What has happened? Bank, the lordships wanted the bank to tell what is the amount to keep.
you tell me.
Yes, no, she said it. He said it because this answer because that it is about 2.4 crores.
Yes.
But actually the due is about 1.5 crores. The reason being,
No, we don't calculate.
not necessarily. That is only one reason. They have calculated interest at the rate of 10% by keeping monthly rests of compounds.
Compound.
But there is an order of the ERP saying that it should be simple. If calculated simple interest, it comes to 1.5 lakhs. Your lordships are expressed in all favors that 20% of the amount be deposited in 2 installments so that further OTS application can be made. 20% if it is calculated that rate as per the ERP order, it should come to
30 lakhs.
30 lakhs.
30 lakh.
That
If amount is taken as 1.1 plus,
1.5.
if amount is taken as 2 plus, as contended by them, then how much it will?
Then the
40
arguments, 30 lakhs.
40 lakhs.
my lords,
40 lakh.
But the
That
question
is
is,
only to show bona fide.
yes.
yes. Well, to show the bona fides, this first installment has been deposited.
Now another 16 lakh you pay.
Your lordship may say that another 6 lakhs because there is already a judicial order. It's not that I am
No, we do
bargaining on
not.
that.
We do not, sir.
I am not bargaining on that.
You go with that order. We will not say this percent or that percent. We are simply saying a lump sum of 40 lakhs.
Your lordship may say,
We'll say that.
with all fairness, I would like to submit. There are 2 review petitions. One review petition is by the borrower. In that review petition, these discussions are now going. Now, in that review petition, if your lordship will say that total 30 lakhs, another 6 lakhs he will deposit within 2 weeks as directed.
No, it's 40 lakhs. It's not a housing loan.
No, my
It is
lords.
a housing.
Is it a housing?
Yes,
No.
it is a housing loan.
Such a huge house he is building.
No, not interest calculations are correct.
You should have
My lords,
interest
it's a
to repay.
CC loan. My lords,
Long.
my lords, to put at rest, today even the bank, we are carrying an interest calculation sheet, my lords, certified by the officer. My lords, that day when I made the statement, it was 2.39 CR. My lords rounded it to 2.4 crores and said, pay 20%, 24 first installment, 24.
We will not say, we'll make it clear. We will not say it is this percent, that percent. We will say 40 lakhs he should pay. You entertain their application for OTS in terms of the extent RBI guidelines.
My lords, to put even the calculation sheet at rest, I'm ready to hand out a copy to them.
No, that's all. All contentions.
All right, all right.
With all due respect, my lord.
Yes, you have said that. Right.
My lord, so with due respect,
Yes, sir.
your lordship may keep this matter after vacation. No.
No, sir.
There is other,
Take them.
no, not for this amounts, man. The other review is what I have prayed for the petitioner. The question that was raised in the petition was whether in view of the clause in the lease deed, whether more bank can take it on mortgage.
No,
your
this is a
lordship-
consensual law.
No, your lordships have kept it pending while considering stay petition.
Where we have kept pending.
No. While considering the stay petition, this discussions came whether the borrower will swear up the loan. The borrower agreed and discussions went on. So what I am saying is, in the event the OTS fails,
Then we will say all contentions are good. In the event OTS fails.
should revive. That is the problem.
My lords,
This amount, my lord, your lordships are now saying another 16 lakhs. That may be difficult.
The other restriction is also by you only. It is by whom?
Guarantor.
One is by
Husband
the
and wife.
borrower, another is by the guarantor.
husband and wife.
Review petition
Consider it.
number 86 of 2026 is by the borrower. And companion review petition 87 of 2026 is by the guarantor. They seek review of the very same order, dated 24/3/2026, which reads as a next paragraph. Having heard learned counsel appearing for the parties and having perused the petition papers, we do not want to undertake a deeper examination in as much as the order dated 24/3/2026 emanated at the hands of this court consensually for the parties. First one. Regardless of the contentions now advanced, suffice it to clarify that the borrower having already remitted a sum of rupees 24 lakh has to remit another smaller sum of 16 lakh within 2 weeks to take refuge under the order now put in review, so that the OTS proposal shall be entertained by the OP bank on a normative basis. And in the event the OTS fails, parties may, the guarantor may seek recall of a review of the order dated 24/3/2026 if grounds do exist therefore. First, next paragraph, we make it clear that the amount of rupees 24 lakh already paid and other amount of rupees 16 lakh to be paid is fixed as a lump sum for showing the bona fide as a precondition for entertaining the OTS proposal, and we have not determined as to what exactly is the amount repayable by the review petitions. Therefore, bank may not assume that the amount we have prescribed for payment as a precondition is on some percentage basis for the outstanding amount. Reflections is going on.
One small prayer.
When are you going to make the payment?
One small prayer. First you said 2 weeks. It's difficult, but then you have some 4 weeks or less.
The sum of rupees, the said sum of rupees 16 lakh shall be paid within an outer limit of 4 weeks, reckoned from this day, failing which, right to move OTS stands forfeited.
Amount can also be little reduced.
No. Next. We are not in Cuttack market vending the vegetables. No bargain. Yes.
Because of the
No.
wrong statement,
Item five.
these things happen.
This is
Yes, sir.
Item 5, WPC
Yes,
3028 of 2026.
Charges is annexure C. Regard to the Tribunal Cuttack Maila, Central Tribunal.
May I payment?
Yep.
In this case, I have instructed to appear. And in the meantime, though this is a covered matter and they have already implemented the order on tribunal matter. I am passing
Whether there was any contempt,
Yes, it continues.
MA for execution matter.
then they have done that. Suppose if the decree is executed,
This is a covered matter, man.
you covered.
Yes, man.
Which just
Basing upon judgment of this honorable passed in WPC number 29466 of 2011, dated 4/8/2022, the London Tribunal was pleased to allow the prayer made in the original application matter. Moreover,
One second. You have said one sentence. Will you not permit the listener to process it? What kind of communication skills? That way was allowed in terms of another judgment.
mine.
That's why Lordship challenging that. That does not.
That referred judgment also you are challenging.
No, that has not been covered in my
Not
case.
covered.
So that is distinguished my law. And K. Lalit Kumar, they have relied upon K. Lalit Kumar case. This is case by that the opposite party had transferred to the Khoda division to headquarters Bhubaneswar East Coast Railway mine. They are clear that they will observe at headquarters mine on basis of that judgment. That judgment he has transferred only temporary basis. In case of K. Lalit Kumar, that is the transfer of option basis. So that is distinguished that only. They are only that. That is I have directed in ground have taken. He is not entitled to observe permanently in headquarters of Bhubaneswar mine. The lien lies upon the Khoda division mine. That is one part. Yes, ma'am.
Where have you taken up the contention that judgment is not applicable?
My lord. In my ground I have taken that. Clearly.
Show that.
My lord. Your lordship. Case 14, your lordship. Ground note F, my lord. F. But that under tribunal passed impugned order by wrongly interpreting the judgment and public order dated 4/8/22 of the Honorable High Court of Orissa, and whereby the Honorable High Court has been pleased to pass an order taking into the consideration orders issued by Principal Chief Personnel Office for transfer to Headquarters Office, Bhubaneswar, on option basis, due to 2 option transfer orders issued by the Railway Administration. That is, one is option and another is not option transfer. But the Honorable High Court has passed order keeping in view of eligibility condition of the staff at the time of exercise option and transfer to Headquarters Office, Bhubaneswar. Therefore, impunity is not sustainable law. Then your lordship.
There is no option exercised by him.
No, mine. That is transfer your lordship on temporary basis. Transfer. He has not given option to transfer from headquarters division Khoda to headquarters Bhubaneswar mine.
Show that.
My lord,
Show the option.
I can show you. Your lordship, can you give me para 5 of the impugned order matter?
No, impugned order is put in challenge on that ground. Now you have to show the earlier order proceeds on XYZ factor.
Mine.
You show those factors are there in your case. Where is one line read? I am giving option.
But I have not received copy. I have with the way copy.
We'll call it after vacation.
I have
Not covered.
I have enclosed the option list where my name is appearing, and taking that into consideration at para 5 of
All
the
this,
impugned order, the London Tribunal was pleased to allow my inclusion application. Man.
Next. Any contempt proceedings are filed
Yes, ma'am.
MA minor for execution.
till next date of hearing. The coercive proceedings for the enforcement of impugned order are kept under suspended animation. Yes.
I may be supplied.
I'll solve copy today. I'll solve copy. In course of the absence.
Next.
Item 6, WPC 9747 of 2026.
Possession of the property is taken without giving any prior letter, without complying any of the provisions.
You go before the DRT. Why are you here?
In fact, my lord, they have not served me anything.
You take that ground also.
Here, my lord, I have written them. Let them allow me entire documents. I have written them. Annexure 1, lordship will find.
You give the documents immediately. When the order was made?
My lord, the physical position was taken on 13/2/2026.
13/2/2026.
My lord. And on 5
When possession notice was issued?
nothing was issued to me, nothing, and I have not received anything, my lord.
Not issued possession.
That I don't know. Khali only I have got the instruction that we have taken all over already position, physical position after doing all these formalities. Whatever we have to do.
But can you ascertain from the bank whether all these notices and other things are given to call your bank manager?
Let it be taken tomorrow. After vacation, after that. Let me supply a copy.
My lord, I have submitted
Give
copy.
Let me, one day it will come. If I'm satisfied, then after my lord call anybody. I'm sorry.
Call tomorrow. You get all the bank documents, whether you have served copies, etc. Do prima facie sure. Otherwise, no citizen will be saved at the hands of bank people.
Now the already possession has been taken over February.
When
February it has been taken over.
No issue. This is a right to residency, the fundamental right.
My lord.
That you have to curtail that. You have to show to the court. We have followed due procedure.
Let it come after vacation.
After vacation.
Let me serve a copy of
In
the.
course of the time.
Give copy. Issue notice. The net panel accepts notice for office. Which OP? Both notice. Both notice. Call
Two sets of copy.
after vacation. First one, vacation. If two sets of petition, two sets of papers are served on the panel council within 1 week, and acknowledgement is filed in the registry in 1 week next following. Otherwise, do not post.
Item 7, WPC 13305/2026.
It may please your lordship, my lords. Lords, I am submitting through BC, my lord.
Yes, sir.
My lords, my prayer is for early disposal of the essay surface application which is pending before DRT since. Sorry, my
Essay 17.
yes, my lords. 30th January 2024, it's pending, my lords.
When it was filed?
30th January 2024, my lords.
Any interim application is made in that?
I have made an application that was allowed, but since, my lords, my only residential house, which is of the only 15 lakhs was due, my lords. For that, my property of 1,24 lakhs has been auctioned. And in the meantime, my lords, at the date of filing of the case, I have deposited that amount also. That way I got the interim order protection, my lords. But since my case is pending, no effective hearing is being done, my lords.
All right. Will you permit us to write the judgment now? Let me.
My lords.
Short grievance of the petitioner is against arguable long pendency of his essay number 27/2025 filed on 30/1/2024 before the DRT under section 17 of the Surface Act 2002. First one, counsel for the petitioner submits, and we agree that right to speedy justice avails even in matters of the kind in view of a catena of decisions of the apex court. First off, in view of the above, notice to other side having been dispensed with, the petition is disposed of, requesting the learned presiding officer of the tribunal to hear and dispose of the essay on war footing, keeping in view the mounting workload on his shoulder. First, all contentions of the parties are kept on. Next.
Item 8, WPC 13730/2026.
Item 8, my lords, I am for the petition. This is the second round of the petitioner, my lords. My lords, I only pray let them give me the copy of the loan account. I will settle the loan within 2 months, my lord. 1 month was granted by your lordships.
I got instruction to appear for the opposite party banks. My lords, on 10th of March, your lordship had specifically directed the petitioner to either clear the loan dues within 1 month or hand over peaceful possession of the mortgage property even without raising a finger. That was the exact wording of my lordship, my lords. My lords, here, your lords may kindly have a look at the
Quoted in page.
order, my lords. And my lords, after that, neither did he repay the dues nor did he hand over possession.
No, he says, I do not know what are the dues.
My lords, I only want the dues.
More than
My
one
lords, it
crore,
was
my
being
lords.
handled by my father, my lords. My father has suffered a brain stroke, my lords.
Solid. What is the amount due?
My lords, as per my instructions, my lords, as on 16/5/2026, it's 1,02,12,515. On 10th of March,
Slowly, just. On 16/5/26, it was
my lords, 1,02,12,515.
1,02,12,515.
Your lords may kindly glance.
1,021,2515.
1,500.
No,
Your lords, your lordship may kindly have a glance at your lordship's order.
No, we'll have to remember all these things.
And your lordship had also expressed a view that that would amount to an act of contempt also if it doesn't comply with the lordship direction. He has not complied. Even when the bank sent a reminder enclosing your lordship's order that returned with the postal remark refused.
Enclosing copy of the
Yes, my
statement
lords.
of account.
No, my lords. No, my lords. Not
You're
the
asking
statement.
My lords, the postal remarks came
Why
as
can't
refused.
you hold back yourself? Resist your temptation to argue.
No, I'm sorry. I'm sorry.
We are asking you whether your letter accompanied the bank statement.
No, my lord, High Court's order was in place.
Answer what he should do. What is the amount due? Whether order mentions what is the amount due?
No, my lords.
It does not.
Yes, my lords, but he also never approached the bank also.
You should have sent, brother, so much amount is due from your
He
side.
refused to accept the letter even if we had enclosed. He has refused. Postal remarks show that he refused to accept that envelope also.
No, you give that to him. We'll
No,
give
well,
him 1 week, that week, so that within 1 week he will clear every.
My lord, that postal record only contains the order of the
That's all right. All that will pale into insignificance.
Yes,
Now
my
we
lord, handing
receipt
your
of this
hand
bank.
for your lordship can record that handing.
Within 1 week you have to make the payment.
My lords, give me 1 month, my
No,
lords.
it's only 1 month.
No, because you have played fraud on the bank.
No, my lords, at least 3
You
weeks,
did
my
fraud
lords.
on the court also.
At least 3 weeks, my lords. My lords,
2 weeks will.
my lords, actually the petitioner who was before your lordship has suffered a brain stroke, my lords. That is why I am doing.
For many people, there is no brain at all.
At least,
Handed him over the copy.
Give that.
at least 3
Brain
weeks, my
stroke
lords.
is not a ground for denying repayment to the
I understand. my lord.
lender.
Defied your
Even
lordship.
death is not. Petitioner borrower was before this court in earlier in WTC number 4356 of 2026, which was disposed of on concession basis void order dated 10/3/2026 by us. First off, the operative portion of the order, which learned panel counsel appearing for the bank loudly reads out, comma, reads as a file. Reproduction to para 5.
Page 11.
Learned counsel appearing for the petitioner, borrower submits, and learned counsel, panel counsel appearing for the bank disputes that the bank had not furnished the statement of accounts and therefore borrower could not draw milk under the order aforementioned. First off, learned counsel for the petitioner twice repeated before us that should the bank furnish the statement of account, comma, entire amount would be repaid and therefore bank should be directed to do it. First time. Next paragraph. Though learned panel counsel appearing for the bank resisted the petition on usual grounds, comma, we are of the considered view
that justice can be meted out to both the sides if a period of 2 weeks is granted to the petitioner to make entire repayment, as has been stated in our earlier order mentioned above, failing which the petitioner can be removed by the bank by using physical force with the aid of jurisdictional police from the subject property. First off, in that event, the jurisdictional police, on the production of a copy of this order, immediately swift to the action in aid of the bank.
Let's make one thing. As per the statement, the outstanding amount is 51 lakhs.
Take on that.
Let's 51 lakhs. I'll pay that within 2 weeks, my lord. And for the interest, I'll give them a representation, my lord.
No. Next.
Item 9, WPC 14870 of 2026.
Yes. Any urgency, brother?
Flood.
Honestly.
Regarding the maternity also, they are satisfied because by name they are pleading the opposite parties, the officials.
Because it is arising out of the contempt. You will also just after vacation.
After vacation.
Kindly fix it.
After vacation. Call after vacation. Yes.
Item 10, WPC 15046 of 2026.
Yes, sir.
Item 10, I think what is Ministry of Power is a party. When another matter, Lordship is pleased to issue notice.
Date. Then Calcutta lawyer had argued, na? Yes.
I think this is similar to this case.
Absolutely similar. Only difference is there. In that case, as the facts, one line the facts managers, he is the ultimate master. Government of India, Minister of Power, ultimate master, has made both the laws, Energy Conservation Act and Electricity Act 2003. Now we are sandwiched by provisions made in both the acts. In one, they call it renewable energy consumption. In other act, renewable purchase obligation under Electricity Act 2003. Under Electricity Act 2003, Orissa Electricity Regulatory Commission has made regulations under which I have complied. I have complied my obligation. But so far, the other obligation that has been created by opposite party, central government.
That you are not.
That I am not supposed to, because Electricity Act overrides as per section 174 of Electricity Act, it overrides any other act.
Any other act made by whom?
Government of India.
Electricity is in a concurrent list or in the central list?
Got the concurrent list.
Concurrent list.
Concurrent list.
Whether state has done any electricity act?
Regulation. We are saying regulation.
Under the act.
Under section 181 of the act. And Electricity Act, Lordship, came for a special purpose of consolidating generation, distribution, trading, everything. So I have a better case for an interim order. In this sense, I have already complied under the OERC.
No interim order. We will consider your interim application
along with
that.
That's but difference I have told my lordship. I have already complied.
Let us see that.
This is the order. Oh, your lordship have passed.
Any interim protection is granted?
No. Lordship said
issue
notice.
Emergent notice.
My friend receives notice for 1 and 3.
Learned DSG on our request accepts notice for OP numbers 1 and 3. Emergent notice to the rest.
2
1, 2 and 3.
1 and 3.
1 and 3.
2 Bureau of MRT.
1 and 3.
Energy efficiency. Only 4. No, emergent notice to 4. All this matter along with other case in WPC.
Only request lordship fix up a date after vacation.
Immediately after vacation.
No date, lordship.
Date we cannot give because we do not know what is the bank, the bench composition and other things. We don't want to trouble our brothers. If we continue, we would have done that. We do not know. Therefore, we call immediately after vacations. Yes.
Well, can we add one line? I pray for your worship because
interim application will be considered after service.
Item 11, WBC 1517.
In the event, any course of action.
But
Liberty
the event
given to
coercive action is taken, the same shall be subject to outcome of the petition. Okay.
Item 11, WPC 1517/2026.
May I please? Yes, sir. Before taking a lordship's prayer, any urgency?
My lord, yes, there is urgency, my lord, since the bank is proceeding, because there is already an order passed under section 14.
14 order is passed.
14 order has been passed.
To challenge
but
it before the
I'm not challenging the 14 order. My lord. Your lordship, before taking your lordships to the prayer, some facts which are relevant, the lordship may kindly allow me to submit those facts. One, Padmacharan,
You read your prayer. All facts may not be necessary. at all.
prayer-
Read the prayer.
prayer, my lords, to
Once you read the prayer, we can assume so many things.
Yes, ma'am. The petitioner has sought for a
Demarcation,
direction to the Tahsildar
demarcate
Satyavadi
the subject line, property, mortgage property, and take possession.
to identify and demarcate the mortgage land before they take actual possession.
Where is your mortgage property, mortgage deed?
No mortgage deed. I am not. I have never. It's a fraudulent transaction, man. My case is the entire in gist. I will present my case, my lord. The entire case is the mortgage has been created by one co-owner over the undivided share and also in excess of the of his entitlement. Total is 4 decimals of land. There were 4 survivors. Suppressing the omitting my name, excluding my name, I am the daughter members. Excluding my name, the mother and 2 brothers, they mutated their name in the year 2015. Now, mother executed a sale deed in favor of one co-owner in excess of her entitlement. Now, that property has been mortgaged with the bank, that is 1 decimal 333 square kodi out of 4 decimals. And if a lordship looks
How
at
can we decide all these things in
my lord,
jurisdiction?
my entire case is, my lord, I am not against the 14 order. Now, if your lordship looks at the 14 order, the
Entire property.
property, my lord, is defective, my lords.
Now, how can we decide? Whether who is the sharer, which co-partner will have? Can we decide those?
No, my lord, I am not praying for that. I am not praying for that. All I am praying is, if the Tahsildar be die, because there is already an order in the 14 proceedings by the collector directing the Tahsildar to facilitate possession, my lords.
Correct.
And if your lordship looks at the property, that is an undivided property.
No, we do not. We do not.
On the face of the record,
No question of face. If you want any disputed fact, go before the DRT. Make that one. We'll observe.
so far as the sale deed is concerned, which has been executed by my mother in excess of her entitlement,
That is what we dispute now.
that is outside the jurisdiction of the tribunal.
Yeah.
Because determining the validity of the sale deed, which is the subject matter of mortgage.
File a suit then.
Yes, my lord, I'll file that.
You
I
file
have also stated in my writ petition. All I'm praying is, if a direction be given to the Tahsildar, they may identify and demarcate the mortgage land, my lord.
We do not do that because it involves, when it becomes a bad, it may become a bad precedent for rest of the cases. We don't want to do that. We do not.
It's a fraudulent transaction.
Well, how can
It's
we
a-
decide fraud?
Because on the, if your lordship looks at the sale deed, 4 decimals of land was purchased by Padma in the year.
How can we decide all this, brother? Can the writ jurisdiction be exercised for that purpose? Go, you can file a suit also because of the apex court decision in Dhulabai versus State of MP. A 5-judge bench decision, AR 1968, Supreme Court page 78, where one person can file a suit, even when jurisdiction of the tribunal is excluded, is discussed by Justice Hidayatullah, the great judge.
If I may
Take out
propose,
that judgment.
if I may propose one thing.
Take out that judgment. We want to refresh our memory. Dhulabai versus State of Madhya Pradesh. This is the AR 1969, Supreme Court 78. I said AR 68, SCR 3662. 69, page 78.
Oh, bless.
It's a great judgment. You take shelter under that judgment. Right.
If I may propose on small prayer, if
Yeah.
I may be protected for some.
We will not protect it.
Because
Because
I'm a-
protection is not available even under that judgment.
No, my lords, what is the situation, my lord?
Heard
There's a
protect
dwelling
oneself
house,
from
my
the
lords.
petitioner.
My lord, I'm
The
a
petition prayer reads as
disabled persons, my lord.
we are afraid that too many contentions founded on disputable facts are advanced before us, and we cannot undertake their deeper examination regard being had to conventional constraints which a report will have under Articles 226 and 227 of the Constitution of India. First one, it hardly needs to be stated that petitioner has got an alternate and equally more efficacious remedy of a suit in the light of Constitution bench judgment of the Apex Court in Thulabai versus State of MP, 1969, case 78. First, in the above circumstances, this writ petition is disposed of, reserving liberty to the petitioner to avail the alternate remedy. First, it is also open to the petitioner to move an appropriate application for grant of interim protection if grounds to exist there. First time. All contentions kept open. Next.
Item 12, WBC 15384 2026.
Which was approved before this matter for consideration. E-auction of Annexure 1A, page 9, one dated 26/5/2026, page 10, serial number 2M. Regarding for earlier e-auction on 11/4/2020.
Are you a borrower? How much money you had borrowed and for what purpose?
On 2011, I have received only PMEGP, Prime Minister Employee Generation Program, oblique SC/ST, oblique scheduled caste, for 10,70,000 some odds, 10,70,705 rupees. Which was already been, after that, the present petitioner and the authority, bank authority, has e-auction to the opposite number 3.
How much money you have repaid?
Man had already requested to page 27 regarding for OTS 2 lakhs.
No, we are asking you. How much money you have repaid already?
Already 3 lakhs.
Out of 10,70,000 you have paid back 3 lakhs. Is it true?
PME is only for subsidy for 25%. PMEGP and oblique SC/ST.
That's all right. But even if he is SC/ST, he is a loaning. Only 25% is subsidy.
Offset printing unit.
Whenever you take money, even if God borrows, you have seen Tirupati, Tirumala. Did you go there? What is that? 7 crores. 7 koti. So he has to pay back. Even gods have shown to us that they have to pay back the loans. Is it not? So citizen also has to pay back.
Already the OTS for 2,95,000 last 10th January 2025. As due to his younger brother expired, who has continued his offset printing for
when he expired?
2023.
But OTS is dated what?
25.
10 January 2025.
Page 27.
125. He died on?
Prior to the much prior to
prior to
2023.
My lord.
Then again somebody will die, but death is inevitable. It goes on happening in every house. On that ground, can we tell the bank? No, some death is happening in our.
As due to financial crisis, cannot repay the same amount, but that to approach before the sum of court for consideration like this.
You are bound to repay. It's all public money, our money, your money. Their bank is only a brain for using the public.
I'm considered on that ground. I'm ready to 2 lakhs of same amount to 2,95,000 for.
How? You did not avail that benefit earlier. What Honorable Justice Nagaratna Madam has said. We are not supposed to entertain. OTS is concluded. You do not avail that benefit. You say some brother is dead. Maybe.
No.
But how can this court show any benefit, any leniency in matters like this when judgments of the Apex Court, Bafna and such other cases stare at us?
No.
Not possible.
I'm considering your lordship to.
But you say, can you show some concession to him? You will make the payment.
It is the sale is fixed to 26.5, my lord.
26.5.
And the outstanding is on 1/7/2024. 18 lakhs 41,693 someone.
Suppose if we give 3 months time to repay the entire money, you take it. Let the first installment be paid now. We'll give it 3 months.
Your lordship keep it tomorrow. I will take instruction and copy may be served. Because he has filed a case against the bank managers, those who have gone for recovery.
He has filed atrocities case.
Atrocity case.
Take down.
Which has been dropped subsequently.
Petitioner, a borrower belonging to scheduled caste, has coined his prayer as under. First up. Next paragraph. Learned counsel for the petitioner vehemently argues that the money was borrowed on in 2011 under a particular
10 lakhs 7.
Central government scheme where some subsidies available.
Credit and term loan. Case credit and term
7 lakhs, somewhat 7 lakhs 747,000 cash.
That is the policy, the term loan. Case credit of 7 lakhs how much?
3 lakhs 6,000 CC.
Money in a sum of rupees 10 lakh 70,705 was borrowed way back in 2011, and some amount was also repaid. A sum of rupees 3 lakh was repaid by way of subsidy.
Already cash amount has already paid 3 lakhs.
It is not with me, my lord, because he has lost now.
Subsidy amount also 3 lakhs and so also.
He also tells us that there was an OTS facility extended to his client on 10/1/2025.
No.
10/5. 10/4/2020. Page 26.
10/1/2025.
10/1/2020.
10/1/2025.
My lord, he has given an application.
No.
Now already considered on that ground.
He has given an application.
That's terrible, you know.
56. 7
25.
There was an OTS proposal submitted on 10/1/2025 for a sum of rupees
2,95,000.
2,95,000, and no order has been passed on that.
No, madam. Thereafter,
No order is passed on the same.
Second time, first time e-auction on 11/4/2025. Page 11. First time e-auction in favor of the Rajesh Mahanti.
Sale certificate also has been issued now. Come to page annexure 1B.
1B.
Yes, taking instruction, my lord, just now I am saying.
No, we don't entertain such people who file false atrocities cases, who threaten the lenders. What is this happening?
It is in page 28 to onwards.
Before HRPC.
It's non-level action, HRC.
FIR was launched.
Yes, FIR was launched. Final report.
So that bank people will not go to his house for recovering the money. Threatening, holding the cash card. Will not enter.
Pastor Saraswati is
First off, a perusal of the records also reveal that the coercive proceedings of recovery have or in advanced stage under the provisions of the Surface Act 2002. First off, we also notice that some atrocities case was filed against the bank officials, which later came to be dropped by the which court came to be dropped.
Police has given a report, page 33.
And that the jurisdictional police, page 33,
36, last page 36 is the report. And thereafter he had approached the
HRPC.
Human Rights Commission or the page 36.
In that time, outstanding is 14 lakhs for 19,131.
And the police, after investigation, found nothing in the case. First. Next paragraph. Learned panel counsel appearing for the bank very firmly resist the petition, drawing our attention to the conduct of the petitioner and tells us not to grant indulgence in the matter, especially when the petitioner can avail statutory remedy as provided under the 2002 Act. Next paragraph. Having heard the counsel for the parties and having perused the petition papers, we decline indulgence in the matter. Firstly, on the ground that petitioner can avail the statutory remedy elsewhere in accordance with law, and in that connection, all contentions are kept open. First of all. Secondly, the report submitted by additional SP IUCAW, Jagdish Singh Pur, dated 3/12/2025, reads as under. Next paragraph. In the above circumstances, the writ petition is dismissed with observations as made above. First having been made, reluctantly is opposed. Next.
Item 13, WBC 15513 of 2026.
Your Lordship, the petitioner is challenging the disposition notice dated 11/5/2026, White Annexure 1, issued by the opposite party bank seeking to forcibly dispossess the petitioner guarantor from her only residential house.
Yeah, that was given as mortgage.
Your Lordship?
That was given as mortgage.
Yes, it was petitioner's son had availed a loan. She has acted as a guarantor. The residential house was mortgaged. And the loan was declared NPA. Proceedings were initiated. During the proceedings, OTS was approved of 38 lakhs.
How much money was borrowed?
31 lakhs was the loan approved. After NPA, OTS was approved of 38 lakh rupees.
Not NPA. What was the actual amount, principal amount borrowed on which date, for what purpose?
For business purpose, Your Lordship.
Business loan. And borrowed on?
Was borrowed on, Your Lordship. In 2021, Your Lordship, they had borrowed.
We asked the date of borrowing, not year of borrowing, not century of borrowing. Call of provocation.
My Lord.
To enable counsel for the petitioner to read the papers and come back. You are an youngster. You are turning the page after page, wasting time of the court. Very often we have said youngsters should come after preparation. We can't tell seniors, but youngsters we can.
My Lord, I'm
Very
sorry, the
preparation.
exact amount borrowed is 31.95 lakhs. I'm on 12/4/2021.
4/2/21.
Yes, 12/4/2021. The exact amount borrowed was 31.95 lakhs. 12/4/2021.
2021. How much money you borrowed?
31.95
No,
lakhs.
it cannot be. Your account has been termed as NPA on 1/3/21.
On that day itself, amount is specified. How can it become NPA before you borrow?
Yes. And bank
It is
demand,
like a death before borrowing, before being born.
bank issued demand notice on 12/4/2021. So you took loan much in 2019.
Call tomorrow. read it, come back. Don't turn back, just like this.
Kindly give me your passover. I'll just.
Go on. Next.
Please, Your Lordship. I kindly request you just a passover, Your
Next,
Lordship.
next. Yeah.
It is very urgent.
No preparation, but not mislead the court. If you know, you say, otherwise, you say, I'm not fully prepared.
Page 17, Your Lordship. Page 17, Your Lordship.
Page 17.
Page 17, the details of the loan are given. Page 17 of this petition. CC loan of rupees 8 lakh on 30/9/2016. Term loan of rupees 23,56,293 on 27/9/2019, and a COVID loan of 39,493. The NPA was declared on 1/3/2021 and of rupees 35,18,662 rupees.
How much money now due?
Your Lordship, out of 35 lakhs, we have paid 4 lakh rupees. The guarantor is ready to pay 15 lakhs within a period of 15 days to save her residential house. And the rest amount she'll require around 3 to 4 months to pay.
3 to 4 months is a long period.
But 15, if she pays 15, half of the money is recovered, Your Lordship. Within 15 days, she's ready to pay 15 lakh rupees to save her residential house. Because they had...
You are for the banker.
Union Bank of India, madam.
Yes.
Union Bank of India.
Union of India is.
No, Union of India is a party.
Union Bank of India. Union Bank of India.
Union Bank of India. Brother, that guarantor is ready to pay 15 lakh. Still you want to take the house? How?
I think this is the.
Now, assuming that there is a 14 order, they are ready to pay the bill.
Because they have obtained a magistrate order in 2023. Now they are coming to us to vacate the house within 10 days.
That obtained it in 2003 and coming to you now.
Only 10 to 15 minutes in the time, I will take Instagram.
You take how much money?
Definitely.
If she pays 50% of the money,
Definitely.
then you have to be gracious. Yes. Otherwise, the people
Only
lose
10 to
faith in the
15
banks. Huh?
10 to 15 minutes.
There is no problem. You wait till you
Yes,
go
yes.
have a cup of tea and come back. Okay? Yeah.
Item 14, contempt 2850/2026.
Yes, Lordship, the Lordship may excuse me for filing this content application because Lordship, by order, in page 18, my Lordship said that this ought to be implemented forthwith, my Lord. That is the reason why I was constrained to file this contempt application. Page 18, my Lord. Last para. It is that item, similar to item 3. Item 3, I had placed this order. In the above circumstances, page 18, my Lord. In the above circumstances, this appeal succeeds the impugned order of the Lord single judge set at naught. The writ of session is issued, passing the order to impugned in the writ petition. As a consequence, the employee shall be continued in the deployed department forthwith. This party also granted him 58 weeks time. Absolutely, I have no grievance. My Lord, I have not also. I represented my Lord to that is the Lordship passed order on 20th April. My Lord, thereafter, 24/4 after getting the certified copy, I applied them and requested to join. There are submitted joining report. I also report 29/4 also I represented the collector. Then also to Land Records Commissioner on 29/4 itself. And but till now, my Lord.
Yes, brother, you want to appear?
No, he's allowed.
You appear for whom?
No.
This is it will come for admission.
State. State.
Will issue police note. Because the order is forthwith should be taken. They are not taken. First, abiding by the order.
That's
If court says jump from the 3rd floor, you have to, unless you bring the stay. Otherwise, no meaning in our order. So far as orders are concerned, we are ruthless in implementation. Issue police notice to the contemners. That notice for me. There is a threat clause in the caution. Look into that. So, the thing of the law. When returnable law, reopening. Reopening.
Deeply obliged.
Item 15, Rate appeal 2157 of 2024.
Yes.
Here I am going the respondent. There is a delay of 671 days. That is one part. The other part, the judgment on the basis of which my case was disposed of in terms of that judgment was not only upheld by this honorable court in division bench, but was upheld by the Supreme Court, and they have implemented in the meantime.
In appeals court, it failed.
It failed and implemented already.
They have taken up the contention that the judgment which has been relied upon by the judge, that single judge is bad.
Lordship, is matters ballot item 15 to 18 ballot allotted to Mr. Ballot, my lord senior Mr. G ballot. So very much this lordship I pray for passable ballot or after lordship.
Yes, 15, 16, 17, 18.
Item 19, rate appeal 1550 of 2025.
My lord, in this batch of appeals by the state, where, my lord, the honorable single judge has relied upon one judgment passed in some other case that is referred in paragraph 7 at running page, your lordship may see 29. Paragraph 7, it has been stated that placing reliance on the said order, learned counsel for the petitioner contended that pursuant to the order passed by this court on 27/9/2023 in WN number 1739 of 2022, wherein this court directed to provide appointment to one such candidate who has either earlier sponsored by the committee in the year 2014, the said candidate was provided with the appointment by so and so date. Copy of the said order is kept on record. My lord, I have checked up this order and that particular writ appeal. It is not akin to the case. It is not similar. Facts are different.
Where have you taken up that contention?
That ground we have taken. That ground we have taken, and these appeals involve very complex fact, and that was a very simple premises that was allowed. I can produce that order even before your lordship. That record is to be placed before for reference of your lordship in these appeals, because the honorable single judge are relied upon and they are also relying upon, but I am not relying upon. Ground is that
that reliance by the learned single judge is bad. Where is that ground?
Yes. My lord, page 15, ground number D.
15, ground D.
Ground D. For that, the Honorable Court have relied upon order dated 27/9/2023, passed in WN number 1739, as and directed appellants to provide similar benefit for appointment as issued in favor of the appellant. However, the facts and ratio of Sanjay Kumar Mallik's case differs from the current case, and Honorable Court have failed to appreciate the fact that the ratio of Sanjay Kumar.
That judgment?
Yes. Right.
Thank you, Mr. Banda, for giving 2 copies to us.
Yes, please.
What was that case about?
There was apparent an error on the face of record, that is paragraph 5, your lordship may see, that percentage of marks secured as 74% was typographically reflected as 64%. That was the sole discrepancy was pointed out, and the Honorable Court directed that's a face apparent on error apparent on the face of record. Therefore, you correct it and reposition the candidate in serial number 5. And accordingly, that was made. No ratio was decided, no law was decided in that case, my lord. And these appeals involve complex nature of facts, my lord, and it will take at least 1 hour, my lord. And before vacation, I pray that it may be posted to the reopening week, because complex facts are involved and it is not related to the cognate case which is being referred to. Only discrepancy regarding the.
Our case was decided on the basis of the facts available on record below. So far as this writ appeal is concerned, your lordship may kindly see paragraph 1 to 7. These are the contentions were recorded by the Honorable Court. And paragraph 8, the Honorable Court has passed the order. That is the findings of this Honorable.
Because the ground is taken.
We are out of employment since 2014. Other persons, our juniors got the appointment.
This matter second week of July. Second week. Any coercive proceedings are taken? Any contempt proceedings are taken?
Contempt, they have first contempt already over, my lord. Court has granted them time to.
We are asking a question.
Second contempt proceeding, in contempt proceeding, my lords are directed not to proceed, my lords, and I am not proceeding. In first instance.
In the contempt proceedings, we have said that.
Yes, my lords.
No, contempt proceeding. No, in read appeal, your lordship may see that.
No. Yes, in read appeal, my lords have
We
said.
have said that.
My lords have already said that. My lords.
Where is that?
That is, my lords, sir.
If then it shall not be precipitated. On 24.
Interim order will continue.
Interim order is
Interim order to continue till next date of 4 years.
Interim order of stay, my lord.
Interim order, whichever interim order we have made, not to process the contempt.
That is not reflected. Can you please refer the date,
21st 4 to 30.
21st 4. I am so grateful. I am so grateful. My lord, I am grateful.
Item 20 has been adjourned. Item 21, WPC 3977 of 2026.
Bank minutes in this case, this data has been disposed of minutes, giving liberty to approve the BRT minutes. But again, they have filed another minutes IA.
For what?
Minutes.
For review.
No, may not be review, but in the meanwhile, we have obtained the order under section 14 minutes.
20, this is 21, no?
21.
21.
In the meanwhile, we have obtained the order under section 14. I think that.
No, but you have passed order on 17.
Yes, minutes. To approach the minute here.
That was the final order.
Yes, minutes. So you can approach the minute DRT minutes. Even if there is the second 14 order.
Is it wrongly? It has been.
No, minutes.
Then
again, he has made another IA.
Where is that? IA.
Oh, yes, IA. In the disposal of case.
Oh.
Where is counsel?
Nobody's doing
Let him. In his absence, how can we discuss that? Yes, call application. Whenever counsel for the applicant petitioner to come and argue.
Item 22.
Yes, brother, one second. That lady, that gentle lady. Yes. What is the position?
One essay is pending. One brother is conducting counseling the essay.
That is saying.
Now the sales certificate has issued, man. What? 1/5/2025, the sales certificate has already issued, man.
1/5/25.
Yes, man.
We are not aware any second sales. One e-auction sale took place. It was declared infructuous because no bidder take. But any second one, we are not aware of it, Your Lordship.
Was it whether second sale was published in the newspaper?
That also taken issue. Now I received a copy, my lord. Received only 5 days.
Because on 21 they are
whom it is sold?
Right, so that matter tomorrow, my lord. All documents.
Yeah.
Item 22, WPC 5186 of 2026.
21. 21 is not continued.
No,
21 was application.
Interim application.
How that application is maintainable?
Yes,
you filed review.
I filed that essay before the tribunal as per your lordship's license. Now, therefore, impact on the application of the bank notes. The CGM has passed the order of eviction.
Eviction order under section 14 that you have to challenge. We will allow that to be challenged once. That copy is given to him. You give copy of the order for that so that he can challenge that.
Because in that case also, he is disclosing that he has already made support. Yes, sir. He can also challenge that.
This petition was disposed of by us by order dated. What's the order dated? 73/2026. Relegating the petitioner to CRT. Counsel for the petitioner submits that. Are you before the DRT?
Yes. I am second.
In
Pursuant to say,
Essay is 5 minutes is not numbered. Even though essay is 5, yes, there is another 5 minutes.
Counsel
It is
for
25th March.
accordingly, essay has been moved before the tribunal and it is yet to be registered.
Yes.
First, he tells us that in the meanwhile, the OP Bank has secured an order under Section 14 of the Surface Act 2002 on 3/4/2026, and therefore petitioner needs to be protected from the court's action. First of all. Next paragraph. Learned counsel appearing for the OP Bank submits that an alternate remedy avails even against the Section 14 order of the kind, and therefore petition should not be entertained. First of all, we agree, we broadly agree with this. Then for challenging 14, we'll give them 2 weeks. In the meanwhile, don't precipitate the matter. Having heard learned counsel for the parties and having perused the petition papers and application as well, come on. This petition is disposed of, reserving liberty to the petitioner to seek redressal against the Section 14 or against Section 14 order before the it is before DRT. Before the DRT, either by a separate proceeding or in the pending essay which is yet to be registered as the case. First off, in that connection, all contentions are kept open. First off, to facilitate doing this, the bank is requested not to precipitate the matter for a period of 2 weeks from this day.
Correct.
Item
we have already not sold the property now.
All contentions.
Correct.
My lord, in item number 19, this disposed of matter record may be tagged. So that referred
along with the 19.
May I please
Place the record.
Item 22, madam.
Item 22.
Yes, my lord.
WPC 518.
My lord, as per my lord's order, on dated 8/4/2022, my lord specifically directed to deposit 5,50,000.
You have deposited now?
Out of 5,50,000, now already 5 lakhs already deposited.
Another 50,000 to be deposited?
Yes, my lord. Because 50,000 not deposited on the ground that the petition number 1 became paralyzed, my lord. The report also, I have submitted the report.
My lord's order was so to deposit that amount in question within 3 days. That is lordship's order.
But he has deposited when?
He has deposited is 4 lakhs for family.
Yes, deposit. What is the amount to be deposited?
My lord, that is as per their interim application given.
That is the 5 lakhs.
23 lakhs is due. The reason being, Lord, this person has taken other loan and the loan.
If you say this person has taken, looking at him, we think that he has taken the.
My lord, classification of the NPA is always a borrower wise, not in account wise. Account wise.
Borrower specific.
Because yes, for that reason, he has taken a business loan, he has taken a credit card loan. In the he has also annexed that letter issued by the bank. The due is 23 lakhs amount. Now he has stated that 5 lakhs 50,000 was the rest of the amount we paid.
When are you going to pay back the money?
My lord, 23 lakhs total loan amount of 23 lakhs. One
bank has given
bank is all yes ma'am. All the four accounts 23 lakhs. But so far as
due. Four account, how much money is due?
23 lakhs 30,000.
23.5.
Yes.
23 lakhs 30,965.
23 lakh 31,000.
Yes, ma'am.
Yes, now, if he has paid,
he has paid 5 lakh, he has paid. Remaining amount, when are you going to pay?
One thing.
Don't argue anything. When are you going to pay?
Sorry, madam, one thing I pay. So far as loan, house loan is concerned, only 10 lakhs. Out of 10 lakhs, already I have deposited 5 lakhs already. Deposited. Rest 1 month may be allowed. So deposited all the amount.
My lord, the proper.
No, the NPA is a person for the borrower, not the borrowing.
Yes. Because the petitioner one suffering paralyzed, my lord.
Everybody will be suffering, brother.
Paralyzed.
Suffering is no ground for not paying the.
No, entire amount. My humble prayer before this honorable court only.
Otherwise, we are going to dismiss. If you tell some reasonable period.
Months may be allowed, my lord.
1 month again.
Your lordship. Your lordship. This is just a
2 months will give.
See, if we delay, then he will make it 3 months. Initially, he asked for 1 month.
You have to go for
2 months.
14 and all other things. Here only will complete that. All right. Suppose if you do not pay within 2 months, what should happen?
No, I will pay. No.
Pay, we give you everything. In the event you do not pay, we'll make it clear.
Yes. My lord, sale has been confirmed, but further proceeding will not be acted by the bank. As per my lord's order. If will
Now confirmed.
Yes, because yes, my lord has categorically stated in the event not paid, eventually the auction of the security property that was held on charge 4/4/2026 may be confirmed.
But you have not yet confirmed.
Confirmed, my lord, because he has not complied as per the lordship's direction amount.
To whom you have sold it?
The auction purchaser, my lord, yes.
Give that in a particular office.
Yes, my lord.
But possession not yet hand out.
It's all right, but the confirmation has been done. Now, so you have to make payment to the auction buyer also. We do not know whether he will agree or not.
With the lordship's concurrence, if you will pay the rest of the out of 5,50,000, 23,30,000 minus 5,50,000, rest of the amount within 2 months. Bank will not proceed further in the matter. If you will not pay, the bank will confirm the fund proceed in the on the
taking possession of the property.
Yes.
Suppose if he pays, what you will do?
He will pay this amount. This amount. That amount deposited to the auction project to be returned.
And he says, I will not accept the return. Then I have auction. I will participate in the auction to get the property, not for getting my money back.
The right has accrued.
Right has accrued now.
Right is in favor of the auction purchase.
You implead auction buyer also. Petitioner to implead auction buyer and bank to furnish full particulars of the said auction buyer. First also. If petition is amended, if cost data of the petition is amended by arraying the auction buyer, then issue emergent notice to him. First also. Next paragraph. In the meanwhile, if the petitioner pays 25% of the outstanding within 2 weeks, further steps pursuant to auction in question shall not be taken by the bank. First, next paragraph. We put the petitioner borrower to the question that if the above direction is not complied with, his petition runs the risk of dismissal on that ground itself. Within 2 weeks, 25% of the amount should be paid. Okay. For remaining amount, let us see. If he agrees, then we can do. Otherwise, we cannot do anything. Let us see. We don't do.
Let my lord know further action.
Yes. If you made a payment, then no further action.
Yes, madam.
Yes.
No bless.
Item 23, read appeal 2457 2024.
My lord,
it's a
transactions will be kept in the record. My lord. I will ask transaction.
No, you share with that along with that. Will not take any document in the open. We are not registering.
Item 23, read appeal 2457 2024.
It's a state appeal challenging the order dated 8/5/2024, my lord, at page 15, ma'am.
Court said treat it as permanent disability with 50%.
My lord, may I say for 2 minutes? Crux of the point is,
This was appointment for the post of regular teacher.
Teacher.
Which was published in the month of 23rd November 2022. Petitioner was applied under the category of PWD category. The minimum disability category as per the advertisement is 40%.
What disability? Ocular or what is that?
This is a hearing impaired.
Okay.
Physical. So they have obtained the certificate.
Hearing impairment.
Yes, ma'am, exactly. 47%.
47%.
Further, subsequently, when it has been gone to the SCB for reference, then it was 52% temporary disability.
52% temporary.
Temporary. But the act and the advertisement shows it should be a permanent disability. And subsequently,
3%.
52%. 52 permanent disability, temporary disability.
But 47 was permanent.
47 was permanent disability.
47 was permanent disability.
Yes.
And you doubted it.
Yes.
Therefore, you sent him.
No, we have not sent. That is the crux of the point. On our own neck, gone to AIMS and got the 52%, that is the permanent disability.
No, temporary.
No, my lord.
52.
52 is temporary, na?
52 is temporary given by the SCB Medical College. Subsequently, on her own account, gone to AIMS and got the 52% as permanent. It is temporary, that percentage is same. On that score, it was not accepted.
Why you repeatedly went for?
We have not sent him.
They have not sent.
Millard, initially in the year 2016, she was tested before the medical board at the SCB Medical College.
She was found to be 47%.
47% was permanent in nature. Right.
My lords, may look at page 58, that is available for the sake of convenience.
All right. The 52 temporary was assessed when?
52 temporary is assessed by the, it is at page 66. Page 66.
5/2/2024.
Yes, ma'am. 56, kind of a glance. I am at serial number 7.
52 permanent was found when?
Millard.
And this is at
the year 24, Millard.
This is in additional affidavit. Of course, that was not in the read. Subsequently, they have filed it, my lord. So this is in additional, by way of additional affidavit. It is at Annexure 9 to the REIT application, which was filed under the additional affidavit.
What's Annexure 9?
Annexure 9 to the REIT petition.
Which by additional affidavit.
That is 4/4/2024, Millard.
Date is not there.
Millard, Annexure 9.
On the right side at the top, 4/4/2024. And the left ear, right ear. One is 50, another is 50.
Why our office will put signature on dates and the seal on the dates and other things? Are they common sense? Should they not put the seal elsewhere? How to read it?
No, the circular is also there to that effect.
You are not to tamper with any contents. You should put your seal on the rock bottom or on the forehead, as the case may be. Why the office, whether cowherds are working in the office? Cowboys. No, you tell them. You ask the Registrar Judicial to come to chamber. This is not one document. Almost every alternative document is like that. why you went to, see, you had already 52% temporary, that 52% temporary was given by whom?
By SCB medical. SCB medical.
SCB. SCB medical.
Sriram Chandra Bhanjam Medical College.
SCB medical Cuttack.
And the hospital.
SCBC. All 5 to 24.
5 to 24. No, why you went to, after you got 52% temporary, why you went to
on
aims?
Because on being dissatisfied, earlier they have, the same institution has given 47% permanent.
Correct.
Thereafter 52% temporary millard. That's why the petitioner moved to AIMS, the better institution of the medical science millard.
Which is that judgment we have held in one case. In one case we held, once certificate is granted, that unless the grounds are shown as to why you go to another test, passage of time, etc. This was on 5 to 2024. The other one was 4
2024.
No, we do not agree. We will be laying down a dangerous precedent. Then the certificates will lose.
It's an entity,
Millard.
It gives it gives doubt.
Millard, my humble submission, Millard. In the similar circumstances, Millard, in the on the same advertisement, Millard, in another case,
they have done that.
They have done.
Therefore,
that.
You also went.
No, Millard. The government has complied the same order.
Maybe
that the petitioner in his own accord. Earlier he was got 45%.
We'll put an end to that now.
Millard,
put an end to that by this judgment. Nobody should go on doing that.
Millard, there is another judgment, Millard. Your Lordship, give some time to me. That in case of admission to the MBBS course, Millard, there is also a similar conflict, Millard. The state highest institution in medical science and later on by AIMS, this visibility certificate, in that case, Millard, the institution AIMS certificate was accepted by the court, Millard.
But we do not agree.
Millard,
law is settled up there. One certificate has been issued. You cannot go on searching for a better committee to grant security certificate in his favor. I will put an end to this.
Millard, I go down your Lordship's view, Millard. But
we have already held that way.
Millard,
we did not agree with the reasoning supplied by the single judge. That is also.
No, see that WPC 1479 of 2025. We have already put an end to all this.
Millard, I'll examine that. Your Lordship, give some time.
Millard,
after vacation, I'll
call it 2 p.m. Copy, give that copy of the judgment. There is nothing, it's not question on the verdict. Simple judgment. We cannot go on having certificate after certificate in the law. We are against you. Just read the judgment and come back at 2. Just give copy of that to learned friend. Yes.
Millard, may I hand over these 2 copies? But the state government are also
you afterwards too. At 2 o'clock you give them. There will be no end. That gives an impression that something is amiss. Yeah. We don't say anything more than that.
Millard,
because all learned members of the bar are sitting, they understand. Yes. Not on you. Not your client.
No, Millard.
What you will do, you'll argue your case. What you should do. Yes.
Item 24 has been adjourned. Item 25, WPC 18132 of 2024. Item 25.
Consent from my counsel is ill, that's why will not be released. After vacation, there is no urgency.
Yes. No, my lord, my pray after vacation. Yes, next. That's the request.
Item 26.
Against the order of contempt, I have come. So, in spite of the order of the tribunal was complied by the railway board. Railway board in series of letter communicated to the general manager. You implement it, my lord. In spite of that, it was not implemented. I filed contempt. But in the COVID time, the appellant counsel, my lord, would not appeal for the CAT. So accordingly, the content was dropped.
On that ground.
On that ground. You to only
Remand the matter, let them decide it. After what? Because he was absent. Any detailed order is first.
No, my lord. After my show cause, Annexure 9, page 36, the in absence of suitable explanation, the wording is there. Accordingly, the MA is dismissed. Miscellaneous application is dismissed.
MA was for restoration of the contempt.
For restoration of the contempt.
What kind of judges or what tribunal?
But in the meantime,
for restoration of first dismissing for default itself is false. And you don't restore which is dismissed. They want all lawyers to be troubled or what? All sadistic.
Annexure 9, page 36. So in the meantime also after retirement because the order was there to give him promotional benefit.
Hey brother, DST, what kind of judges?
See this second paragraph. They paste that 36 Annexure 9. The CP was listed on 31/10/2022 on the submission of Land Council for the respondent that the order of the tribunal dated 7/9/2019 OA number such and such has been complied with. The CP was dropped.
Subsisting. Kind of. Where are the elements of justice? We have taken oath to do justice in accordance with law. Where are the elements of justice in this order? Contempt is dropped on the ground of default. CP is filed for restoration. And CP is first dropping the contempt. Why he should be present? Contempt is brought there. It's the duty of the court to see whether our order is complied with that. Why counsel?
Contempt, there is no need to be present.
That's why. It's not a criminal proceeding.
Yes.
Technology. We'll remand the matter so that we'll restore that contempt proceeding. Let it happen.
Yes.
Only reservation that they can protect to us.
Some contentions will keep.
Yes, yes.
This petition by the employee filed under Articles 226 and 227 of the Constitution of India seeks to call in question the Cuttack Central Administrative Tribunal's order dated 23/4/2024, a copy whereof avails at Annexure 9, whereby the CP number 73 of 2020,
73 of 2020.
Essentially seeking the restoration of the contempt proceedings that were dismissed for default, has been negatived.
is dismissed.
MA 705
to be restored.
MA 705 of 2023. Whereby, read it now. Whereby, contempt proceedings in CP number 73 for 2020. Next person. After service of notice, learned DST assisted by learned CGC, Mr. DST, Mr. Party, assisted by learned CGC number so and so, vehemently opposed the petition, saying that the impugned order is a product of exercise of discretion, and such discretionary orders do not call for deeper examination. First, next person, having heard the counsel for the parties and having
only one line. Plus, add that this speaking order was passed by the authority and it was also. Maybe election A by 1 upper.
He also adds that it is a speaking order.
Well, speaking order after judgment, it was my argument for the court. The representation was not to dispose of. After the judgment, and the railway board implemented it. So the GM cannot pass the speaking order.
Added to this, a speaking order has also been passed.
Order 8/9/2022.
On 8/9/2022.
Subordinate to the railway board.
And by the jurisdictional authority, and therefore interference of this court is not warranted. Next one. Having heard learned counsel for the parties and having perused the petition papers, we are of the considered view that MA 705/2023 ought to have been favored, and CP 73/2020 ought to have been restored to the board for being considered on merits. Merit. First off. In fact, the order impugned before us does not reflect the elements of justice with which orders of the kind should be pregnant. And that would constitute an error apparent on the face of the record. First, next, in the above circumstances, this petition proceeds. Second, impugned order dated 23/4/2024 is quashed. Seventh, petitioner's MA number 705/2023 having been favored, CP number 73 of 2020 is restored to the board for consideration on merits. Of course, after giving opportunity of hearing to all the stakeholders. First of all contentions are kept open. Stop box.
One, and it is, let's say, not express your opinion.
There's some contentions are kept open, and that we have not expressed any opinion on merits of the matter.
This statement is degrading the power and prestige of the court.
How? I don't understand.
Merit of the case.
One argument you are doing here, another argument given tribunal.
Without merit of the case.
Mr. Mahanti, I never degrade my own. I told
this type of
for your
this type of
instructions cannot be.
Obviously, it was not there.
Both of you go to the copy. Both of you go to the copy.
4 years back, 5 years back, it is a recent invention.
We'll come back.
What will
after having our lunch. Yes.
Item note 26. After vacation, my lord.
26. Who is your opponent?
I am for the respondent, but I have no objection.
Immediately after.
Yes, Delhi list, madam.
Entry order to continue immediately after vacation.
Next item also be not
Daily list. So, interim order to continue. Interim order any shall continue. There is some music also. Yes, sir.
Next item also.
Item 27.
Absent, your lordship. There's a predecessor complete, will be heard.
So we kind of fix a date after vacation.
After vacation, immediately after vacation.
Let's say for
Entry
date
order
is
to
not-
continue. We can't fix
There's an
it.
interim order.
Other judges, if it is changed, it may not, but we do not know.
Let
us hope that
order against us.
entry order to continue. In next date of. Yes, doctor, you were saying some of the.
Hello.
Counter affidavit from petitioner.
Who is the petitioner?
Opposite party, from the opposite party.
Whether your party is, your friend is here. Because getting matters posted itself is a Herculean task in our court. Therefore,
call after case on.
You inform your.
He is present, he is present.
Yes, yes.
Just after they have.
Just after just after it is. Your technology,
Interim order to continue.
Get the request of. So,
interim order to continue.
My appearance may be noted for the petitioner as well, my lord, as a senior counsel.
Yes. Interim order to continue.
Yes.
Item number 23, Miller. Equal some time to examine. You not kindly put up it after the case of
certificate.
Like certificate and along with the lordship's judgment.
Item 15, Writ Appeal 2157/2024.
71 days delay of the state and the respondent. The judgment on the basis of which the
the finality and apex court level.
And that is implemented. I'm giving all the copies to my learned friend also to your also.
Let us see. Yes, Mr. G.
Just now here, served me copies. Yes.
If they have a finality, you will say you have vehemently opposed. You will use all the adjectives.
No, my lord, here appointment was made on contract basis. So subsequently thereafter, they wanted to regularize it from the date of their initial appointment. So the tribunal said, no, you regularize
What the judge then said?
Regularize their services, my lord, from the date of their appointment, notionally. That was confirmed by your lordship as well as by the Supreme Court.
What it means.
And having same day appointments.
You have implemented the order.
Yes.
For the rest of the people.
Yes.
But for all other people, it is implemented.
Yes, yes. No. The judgment on the basis of which it has been implemented.
About 20 persons were appointed,
Yes.
regularized.
Same date appointments. Now, so look to page 2. This is the single judge order referring to OA number 2634 and 2636 disposal in terms of that. This was that judgment I have given. Annexure 2. Let's look to that. That has been upheld by the division bench.
This judgment was passed.
Yes.
In terms of OA number so and so disposed of on 24/4/2012, which has been affirmed by this court.
By this court. Then the matter was carried to the Honorable Apex Court. That is at page 22. The special petition, so far the petition is concerned, 7441.
No, page 11.
Page 11. Yes, page 11 is the division bench judgment where it was dismissed on the ground of limitation. But the page 13, sorry.
13 is
Page 13 is the judgment of the Honorable Apex Court, and that is special petition number 7441 of 2023. In that case, the judgment was passed on merit, and it has been implemented at page 20.
Come to para 4.
Of the judgment of the
Apex Court.
This order is in a peculiar fact and circumstance, however, it shall not be treated that type of thing. But the very same person has been appointed on the same date. Same day, or same advertisement, same date.
No, Apex Court says, you shall not treat it as a precedent.
Right.
Then how can you cite this?
Sir, I only can say that because of the very same advertisement and the very same advertisement appointment was made on the very same day, both the person, petitioner and the judgment which was also directed to in terms of that judgment. They are appointed on the same day. So since they have already implemented in that case, maybe also said that may not be precedent, but this is the case which has been covered by that other judgment of the Supreme Court. Whether it will be from the date notionally, from the date of initial appointment on contractual basis, because that Bholanath, all judgment, that is also squarely covered this case. Admittedly, they were appointed pursuant to the advertisement. They were appointed on a contractual basis. Subsequently, it was regularized, but the benefit of notional benefit was actually extended to them from the date of their appointment.
Mr. G,
My lord.
please come to page 14 of the compilation now Mr. Rautra has given to you.
Yes.
Dr. Hill.
Page 14.
Para 1.
My lord. Delay in filing application.
No.
Thereafter.
Respondents who were appointed.
Right. Respondents who were appointed on a contractual basis shall be treated as regularized from the date of their initial appointment, including regular increment, and be extended all benefits notionally till the date of the order of their regularization.
Yeah.
And be extended benefits, fixation of pay, and other consequent. This order was passed by the tribunal.
Correct. No.
Tribunal's order is that, man. Let's may kindly have a look to
Page
the
9.
compilation of page 9. Accordingly, the respondents are directed to regularize their services of the applicants with effect from 25/3/98. That is the date on which the applicants were allowed to continue as HMOs on contractual basis without any break on notional basis by modifying their prospective regularization orders with effect from 25/12/2008 and calculate the pay and other benefits accordingly. However, actual service benefit and actual benefit shall be drawn by the applicants from 25/12/2008, that is the date of regularization. The consequential benefits treating the applicant to be regular government employee for all purposes with effect from 25/3/1998 be extended to them. The entire exercise shall be completed. But here is a case where they are continuing uninterrupted. Ground says there is a break.
When there was a break?
Specific period was not there. They have stated.
When there was a break, what was the extent, length of break? Because break, for the break's sake, will not be entertained because of that part-time teacher's judgment, AR 91 Supreme Court.
Yes. Rabindra and Mahapatra. Rabindra and Mahapatra.
Odisha case.
Yeah, 1991.
That's 1286. Non-estinai of that. They also said that break period is non-estinai.
That validation act was considered in that case.
Correct.
Odisha case.
So that ground will not avail to you. Now your advocacy skills are required in interpreting the apex court observation that this case shall not be treated as a precedent.
My lord.
What is meant by that?
It means, my lord, this case. Those cases are different. And this case is.
For precedent is a source of law.
My lord.
For the purpose, because with any jurisprudence by Salmon's jurisprudence, Julius Stone,
that cannot be precedent here, my lord.
No, you are explaining. We have 4 principal sources of law.
Yes.
Legislation, custom, contract, precedent, and one weak source of law is opinio juris. Opinions of like Balkiwala. If they say something in writing, then it may be a source of law.
Yes.
Now we have precedent as a source of law.
Yes.
This judgment says you will not treat this as a precedent. Means as a source of law you will not treat it. Does it exclude to grant relief to the other side on the principle of parity, equality, conduct of the government? There you have to make some.
He is protected under Article 14 and 16 of
whether it shall not be treated as a precedent. Does it exclude the principle of equality enshrined in 16?
Yes.
Because it's a service matter.
Yes,
it comes to 16, not 13.
16.
Then where do you stand?
A lot of exactly in 16, because some people have got the
Benefit. How can you deny it to other people?
My lord, like be treated alike.
On that principle. Sir, now what do you say about the observation of the apex court?
Well,
You
that
have
is-
cited that issue.
That is exactly my submission, what your lordship said.
No, you can't borrow it from the.
No, not borrow. That if you have treated the same person, same in a particular way, maybe the judgment is not the precedent, but the super equality article 14 and 16 that they cannot treat it differently to those persons, stands on the same footing.
On that, law has not been developed. Professor Lakshmi Kanta wrote Precedent in Indian law on par with precedent in English law by Rupert Cross. But this aspect has not been considered. But what precedent in English law says is whether a decision has precedential power or not should be decided not by the same court, but by the court in another case when it is cited before that. This is how Professor Rupert Cross answers that question. But we have not accepted with judgment. And Article 141 is not on the basis of precedent at all. Which is that judgment. Take out Barkatullah versus Rudramurti or Rudramurti versus Barkatullah.
No, another set of judgment of this homeopathic medical officer, the Supreme Court has said, so far the precedent is concerned, this case is whether the respondent liable to be covered under the old pension scheme or new pension scheme. The matter stands covered by a decision of this court in the case of state of Odisha versus CHITTARANJAN, that judgment. Although in the aforesaid order it is stated that this order passed in the peculiar fact and circumstances, however, it shall not be treated as a precedent. But since we find that the same set of facts and circumstances arising out of the same state, this especially petition is rejected.
That is sufficient for us. But in Barkatullah, Rudramurti versus Barkatullah, apex court said Article 141 is not founded on doctrine of procedural. That's the lone judgment which said like that. Justice Babu's judgment, Chief Justice Rajendra Babu. Yes, give that. That citation.
Maybe screen have given
in all these cases, how many cases and how many days of delay?
Here is the only one petition.
One petition.
Yes. In the CHITTARANJAN case, that has been said. That CHITTARANJAN has been referred to. That is at page. Yes.
One five. Yeah.
That is also in Odisha case.
Yeah, that's also.
Yeah.
Career advancement.
Yes. I think Dr. Chitra.
What is the explanation for a delay, Mr. G?
Delay caused, my lord, it is very formal application. It was given, my lord, it was delayed from file, from table to table, file is moving from department to department. 97 Supreme Court speaks, my lord, that government.
But after the Ojwas has come in your government, how you can identify where the file remained? Where the file stopped?
Nowadays,
you can know that is the purpose why Ojwas has been taken.
My lord, Ojwas.
Ojwas, ours is Ojwas.
Ojwas. Everyone, and now all the files were moved through Ojwas. So it will be very easy to locate where the file is. But at the time,
the state and its officials have preferred this intra-court appeal. First time. They want to assail a learned single judge's order dated. Which is that? Single judge's order.
But this is
at phase. That is at phase 2 of my compilation. 26th August 2022.
2022, whereby relief has been accorded to the respondent employees by allowing WPC OA number 810 of 2017. First off. Paragraph 3 of the said order reads as an page 2 of this compilation. Next paragraph. As is obvious, next. In OA numbers 2634 and 2636 of 2015, disposed of by the Orissa State Administrative Tribunal or Orissa Administrative Tribunal? Orissa Administrative Tribunal the following relief was granted. Fine. You could take this with me. Okay. Below that, no paragraph. Just one more. We are told at the bar that
both the paragraphs will also make quite. 8 and 9.
8 and 9. 8 and 9. Right. Next paragraph.
Page 11.
We are told at the bar that the above order of the tribunal was put in challenge before a coordinate bench of this court in WPC 40902 of 2021 by the appellant's hearing, and the same came to be negative. Wide order dated 27/4/2022.
A different one or same one?
Opinion is state. State.
Dr. Pragati.
Respondent. Pragati was respondent.
That was the
respondent. State was the appellate.
Yes. Learned senior advocate appearing for the respondent employees draws our attention to apex court decision in SLP diary number 11892 of 2023. Whereby the order, the view of the coordinate bench has secured imprimatur and therefore on the principle of parity, he submits The relief accorded to the litigants in the coordinate cases has to be extended to these clients as well, not on the principle of precedent, but on the principle of parity. First of all, he also resists the application for condonation of delay of
671 days.
671. Kindly be seated, sir.
Sir.
671 days. Saying that there is absolutely no explanation, much less plausible one. First. Next paragraph. Look at the AGA appearing for the appellant's hearing draws our attention to paragraph number 4 of the apex court order in the subject SLP diary number 11892 of 2023, which reads as an paragraph 4. Next, having heard learned counsel for the party and having perused the appeal papers, as also the application for condonation of delay, we decline indulgence in the matter for the following reasons. Number 1. The application in IN number so and so, supported by affidavit, does not offer a plausible explanation for the long delay of so many days proved in filing the A perusal of the application shows that the same is paternalistic and not fact-centric, individual fact-centric. First off, we do not find any plausible explanation for the delay proved. Therefore, the application is liable to be rejected, and accordingly we do it. Next paragraph. There is fourth in the submission of learned senior advocate appearing for the respondent employees that merely because a law laying down court observes that a particular decision shall not be treated as a precedent, the doctrine of equality enshrined generally in Article 14 and specifically in Article 16 of the Constitution of India does not stand excluded from invocation on the basis of observations of the kind. First, in support of this, he places at our hand an apex court decision in SLP number 10598 of 2024 between State of Odisha and others versus Priyambada Pattanayak and another, decided on 9/9/2024, wherein the following paragraph occurs. That observation in the paragraph, the observation in that paragraph broadly supports the view of the net senior advocate. First one. It hardly needs to be mentioned that our system recognizes 5 sources of law, traditional sources of law, namely legislation, contract, custom, contract, precedent, and opinio juris. While summons, jurisprudence, wealth addition, by federal. First one. If a judgment is not a precedent, it cannot be cited as a source of law. First one. That is how the observation of the apex court in SLP diary number so and so has to be considered. First one. There is no indication in the said judgment that it cannot be cited as a ground of parity in matters like this. First one. Next, in the above circumstances, this appeal fails both on delay and on merits. Coupled with a direction to the appellant same to give effect to the impugned order in letter and spirit within an outer limit of 8 weeks.
A little more time may be given because
3 months.
exercises.
Without driving the respondent employees to launch one more legal battle.
Item 16.
One password.
Instead, let it come after vacation.
No matter. No matter. One password.
Records are not there.
Otherwise, you would have given the password. Yes.
Item 17. Read appeals 668 of 2025.
Nurse may condone the delay and call this matter after vacation so that matter can be heard. There is a
item
16.
16, 17, 18.
My lord.
Similar.
It is 17. No, 18 is different.
18 is different.
Yes. In item number 17, the impugned order, lordship.
Delay of how many days? 45 days.
Delay of
who appears for the other side?
45 days only. Nobody has appeared.
Service happened?
No.
But it happened?
No.
Then a notice has to go.
Yes.
Issue notice both on the main matter and application for condonation. Returnable within 4 weeks. Yes.
Item number 28.
Item 18.
Reached at 2 p.m.
28.
Yes, sir. 29, sorry. 29.
এটা 500 sorry যাও
I just wanted to bring to your lordship's notice before your lordship resumes the hearing in that case. The impugned judgment in the appeal can be set aside on a short ground that there are a set of appellants who have filed appeal before the court who are affected by the impugned judgment were never given an opportunity of hearing. There is an arbitration award which has been set aside, which has been set at naught, and transactions which have taken place between parties have also been nullified without affording them an opportunity of hearing. I am in fact one of the persons who has filed an execution case for implementation of that arbitration award. Now that award now stands nullified in view of the impugned judgment. And I was never afforded an opportunity of hearing. So on this short ground, apart from the grounds on which my learned senior friends have argued before your lordships, this is an additional ground, and on this short ground alone, but its judgment cannot be sustained.
Who appears for Mr. Mishra? No. You are for petitioner. Appellant.
That I am appearing for the.
Now, Mr. Mukherjee says set aside that order.
No, it cannot be set aside because the writ appeal is not maintainable. That I am placing my vote of submission.
My case is totally different in the sense that
allow me
in a writ petition, just a minute, in a writ petition, a judgment has been passed. I was not a party there. I have sought for leave to file appeal. That leave application is also there before your lordship. Because when a writ petition makes an order by which I am affected, if not on any other ground, my writ appeal becomes maintainable. Only on the ground that I was never afforded an opportunity, and a leave on that ground can be sought for.
Instead.
Sorry, Mother.
Instead of that.
Yes, sir.
Why can't you go for AR 65 Supreme Court? Shivdev Singh. What's here? Not a new judgment. It is rendered perhaps when I was born, a little when I was a lad. Let's take up that judgment too. Give copy that relevant portion of that judgment to Mr. Mukherjee. Correct. Apex Court said it's a 5-judgment decision. If I am right, I don't remember. So do we have that? Yes, it's a 5-judgment decision.
Well, that may be a remedy available to me, but my lords, when this honorable court is already in session of the matter,
no,
where the legality
with him, because appeal itself is not maintainable.
Yes.
And your grounds, I can consider only if appeal is maintainable, not otherwise. Therefore, I will keep open one ground to you, so that you can approach this one.
In fact, myself and my brother, Mr. Mishra,
yes, sir,
are for the appellant. And on the last occasion, we had not shown your lordship under what circumstances the writ petition was retained by the Honorable Singh Judge. And there are two aspects. First is the impugned order.
We will have this after vacation. We'll call this matter after vacation. It requires real consideration. After vacation.
It's a bit late at 2 o'clock.
Don't know after vacation what after. Yes.
Item 18, writ appeal 111 of 2025.
Interim order to continue. Interim order to continue. Yes.
Item 18.
Item 18, my lord, lordship may kindly count on the. Copy never. Lordship may kindly condone the delay of 405 days.
405 days.
The second case, the order was already implemented in the meantime, much before the filing of the terms.
Maybe what contempt.
No conditional order. To 2023, they have implemented the order of the single judge, and 25 the writ has been filed.
Lordship may kindly call this matter after vacation so that.
Then it is already implemented.
Certain and come back.
Yes, sir.
Yes.
Immediately.
All are out of employment, my lord. They are dismissed.
Your appointment is violative of the government order.
Immediately application.
I am appearing in one of such cases in appeal 560 of 25.
Sure.
Next, I'll be
May I pray for the date? The opening week, your lords.
Item 28, writ appeal 1274 of 2025.
Lordship's last order may kindly be seen for regularization, and your Lordship had also asked them for a settlement.
Yes, Mr. Mishra, what did you do sitting under the shadow of our order?
I had a discussion with the bank people actually who used to come to my friend. We sat together, in fact. Then we contacted Mr. Alphonse, hearing the same. The bank said, let them give a proposal. Because bank dealership knows public authorities, they cannot give a proposal. So you give a proposal.
You give a proposal now. Tell that. What is that proposal?
I told them that they can place it for the board and they can take a decision whether it is acceptable or not acceptable.
But for that long period will not be given.
Sir?
On the reopening day, we are calling this man.
Yes. A day after reopening.
No problem. 2 days after.
You give me a proposal.
Yes, sir.
Well,
Just to articulate the proposal.
My lords, as your lordships felt, so far regularization is concerned, we are continuing from 94-95. So period of from which date they will be regularized, if your lordship comes to the opinion. Accordingly, the financial benefit we can get of a regular employee. One. Second is, if regularization is given, then the temporary pay which accumulates right from the year 2006 onwards, that has to be released in our favor, what a temporary employee received.
They're actually asking for allowing, dismissing their...
No discretion.
So regular...
It's all right, look at us. He is arguing his case.
No, sir, I am not argued. Yesterday, we had a discussion.
He is a wizard in this field. He is a wizard.
All these things.
No, they never came up with any kind of proposal.
Bank will not come.
Bank. So whatever your lordship will suggest, I will go by that.
You tell so that they have to, because they are a statutory.
One thing, my lord, one thing is clear, that since we have worked continuously, and we have done our duty also, performed our duty. So legitimate dues is our temporary pay. One thing. That is that. So far as...
First claim is?
Temporary pay, which is given to the temporary employees, the temporary benefits. Temporary pay and benefits.
In other words, he should be given as a temporary employee, and as a consequence, temporary pay has to be paid to you.
Temporary pay, the differential pay, which
effect from which date?
Which, since we have put in service...
2012, they have filed the writ claiming that.
My lords, as your lordship is aware of, has made a note that the court directed for minimum wages in 2008. They said that we are paying according to that minimum wages. We came up in the year 2012. Thereafter, that no, we are paying. The arrears, some arrears were given towards wages which they were not paying minimum wages. So we have to get the temporary pay as entitled to other employees, because that is the consistent rule.
From which date?
Date of initial entry or what?
From which date temporary status should be granted and temporary pay should be paid?
Whether it is 94, 99, which one the date?
My lord, there are
some give and take has to be there. That is how the proposal.
Actually, my lord, in real sense, if it is, then we have to entitle from the year 94 or 95. If actual date is considered.
94, 95, they were never in the picture.
Never in the picture?
No, they came to be appointed.
Then
95, sir.
95, yes, 95.
94, 95, 94.
One is 94,
another is 95.
This one is 94.
They are 95.
We have given the wages.
Right, let it
down. Yes, sir.
The wages slips are very much on record. For the year since we have filed that on record, it is there. So my learned senior is disputing it, 94 or 95, but it is on record. That is why the differential amount for 1 year, one person got a few thousand more, the other person received less.
Right.
That so
by our order dated 15/5/2026, we had said as under. Next. Learned the senior advocate Mishra appearing for the appellant.
Respondent, I'm sorry. Here
Respondent bank submits that. Since his client is a statutory body established under the State Bank of India Act 1955, if the proposal from the employees comes forth, comma, the management will be in a position to take a decision, comma, maybe with a bit of sympathy. First. Learned counsel appearing for the employees submits that his clients were appointed way back in the year 1994-1995. They have been granted the temporary status and therefore temporary salary has to be extended to them in terms of policy statement dated. There was no such date. Other day you turned the pages and said there was no date. No date. Policy statement. Full stop. When we confronted him with the 2012 order,
My lord.
2012, the order dated
2008 is the first order. 2012 is the
order dated. What is that date?
2007 and 2008.
2007 and 2008 orders. There was 12 order also.
No, 12 order.
It came to be decided.
It came to be decided.
Whatever it was.
The date, if you want, 24/7/2007.
20
and 5/12/2008.
No, first one is
24/7/2007.
2007.
And
5/12/2008.
One, my lords, one thing, your lordship may kindly have a glance at just page 158. There is.
I have read that order. That order is.
So WPC 80.
158, the number of temporary employees working under the bank, that status has been provided as on 2001. So that is serial number 18, your lordship may kindly have 19 and 20, our name is reflected, page 158 in the present writ petition. So therefore that is
passed in earlier rounds of litigation. Submits that the temporary status was granted to his clients way back in the year 2001.
We were shown as temporary employee. Actually, they did not grant us temporary status. To be very clear, my lords, they said you are working on wages. We said that sweeping charges, other things are temporary sweeping charges, temporary employee, the COVID certificate, as well as the
temporary employee, which fact has been borne out by, that is annexed.
My lord, 121. This is a page, annexure 2 series, we have given everything. First is page 113. These are the certificates, the sweeping charges. Then the sweeping. Page 121, 123, annexure 2 series.
Annexure
2 series. And the other is our consolidated page 51, where they are saying that they are getting temporary sweeping charges. And that is page 51. There are all are records. Annexure 2 series is the complete record in tandem given in page 51.
No, you don't name them as annexure.
Yes, it is annexure 2 series.
Annexure 2 series.
Records, 2 series. The page 51, various pages are there. And bonus has been given to them. Page 64 bonus also they have received.
That was disputed.
They have received disputed ones.
No, bonus has been paid.
Yes,
Records are there.
Records are there.
This was recalled. Then an appeal was filed. Appeal also dismissed. They never challenged it.
No, that is a wrong fact.
No wrong facts. I cannot tell wrong facts.
Here, lordship will see page 64. The bonus were paid, but suddenly they came up with a circular in the year 2025. We have received bonus from 2006 to 2022. In between this, in 2012, they said that my bonus was withdrawn. When we filed the writ, they filed a counter affidavit stating that we have paid the bonus. So therefore, no cause of action application survives. So far, yes, sir. Yes,
Sorry,
my lord.
where is that?
My lord, your lordship may kindly see the counter affidavit which they have filed in 2000, this writ application 24692 of 2012. The counter affidavit, your lordship may kindly have a glance. This the bank counter
tells that
the bank's counter affidavit.
clients were paid bonus during the period between 2006 and 2022. Which aspect is denied by learned senior advocate Mishra.
But overwritten,
Be that as it may. First, in our considered view, the party shall sit under the shadow of a tree and explore the possibility of an amicable settlement on the following lines. No, we are only giving. One, they shall decide as to the date, effective date of regularization of services and
liable for perjury.
the grant of service and pension, service and financial benefits on that basis.
Yes. I'll submit to perjury.
Next. The grant of bonus for the period after 2022 if already bonus was granted to the employees during the period between 2006 and 2022, if it is granted, therefore we say we do not know because you dispute and here.
Your lordship may kindly have that affidavit. Their own affidavit that is on record.
No, we have written it. We have
page 49.
We have written
I have got it on record. Page 49, your lordship. So far as prayer for bonus is concerned, the petitioners have already been paid bonus for the financial year 2011-12. Bankers check number so and so dated 21/1/2013 for rupees 3,500 each. So this is they are liable for perjury. This is not.
You said from 2006 to 2022.
2006-7 we were receiving. They had given us bonus. That also certificate. Because they stopped in the year 2012, I came up with this read for prayer for giving us the bonus for that one. And
we have said, taking into account
that is the
aspects they have to do.
Yes, they have decided. It is admitted in their counter affidavit. That must be because they are liable, but they will pick up their own circular, my lords. They're so powerful. We will not get any relief, my lords, from bank.
No, then it will come here only, na? Before us. We are treating it as partnered.
Your lordship keep it partnered. Let's hear the matter if it is not set.
That's all. Parties to come back to the court, hopefully with settlement. First off, we make it clear that in the event no settlement is arrived at, on the next date of hearing, matter shall be heard on merits by this bench itself. How you are going to coordinate?
So this order actually we are going to give it to our authority who actually dealing with the department.
They telephone, why not off the record?
Hardly needs to be stated that the jurisdictional officials of the bank shall invite the employees for negotiation by written notice of 1 week advance.
You're saying that let them give the address or phone number so that they can
Bank has that.
To the
bank has an email ID bank.
brother.
Why not?
He want you.
I'll provide.
State that. Even for that you have
That one I don't oppose. I'll provide them. The bank has their email ID. That is what I said to my son.
Say your, but not banks.
My email ID.
To the employees on the addresses to be furnished, addresses and the mobile phone numbers to be furnished by them to the management. To whom you should give that, whom you should, we will, advocate on record, we'll say to the advocate on record.
Yeah.
To the lovely advocate on record appearing for the bank. Within 1 week from this day. Within 1 week, you should give all that information.
I will provide.
Okay.
Within 2 days.
Call this matter.
23rd or 24th?
How many matters are posted on 323?
On 23rd is 3 matters, 24th is 4 matters.
On 23rd, we'll take.
23rd.
Well, so your lordship's order last occasion said that prima facie they have made out a case for regularization. That portion, my lord, this is for the temporary pay is concerned. Your lordship has directed for settlement. So far as regularization is concerned, from which date they will.
We have not heard it. It is dictated.
Also, the regularization part. Yes,
That's the
part.
first one.
That itself is the first part.
That may be just made clear.
Yes, yes. We have made it clear.
My lord, small oblige.
Still, you have actually needs a copy of
Yes, a confirmed copy of this order to be shared with all learned advocates immediately.
Item 29 and 30 have been adjourned. Item 31, Rate Appeal 1535 of 2025.
My lord, one clarity.
Yes, sir.
So far as regularization is concerned, the local office, they say that we don't have the power for regularization, that the center will do. We will write it to the center for that approval. So that thing may be made clear. That otherwise they will again adjourn it.
It is further made clear that the decision in this regard has to be taken by the jurisdictional authorities of the bank. So that on the next date of hearing, the OPs shall not, OPs are respondents. Respondents shall not plead that they don't have power. So, he's right. Otherwise, you may say we don't have power at all. Yeah.
Item 31, Rate Appeal 1535 of 2025.
Yes.
The entire background fact of the case in short, I am submitting that the district sub-registrar Khurda at Bhubaneswar has refused to register the deed of cancellation of a registered joint venture agreement dated 11/1/2013. That is the entire case.
Which is that
on 20th, my lord, one technical aspect. On 20th February, Lordship may see your Lordship's order 22 to 2026. That your Lordship directed the appellant to array the joint venture partner as respondent number 3. He has arrayed, but whether notice has been sufficient because his presence, your Lordship required his presence.
Notice has been sufficient, made sufficient by 11th, were taken by speed post.
No. Lack of presence is required because the Honorable Court wanted their presence.
This has gone. Notice served already. Well, that party has been avoiding for 10 long years of golden period as a lost.
No, it is unserved, sir. Neither AD nor unserved notice is yet back.
But as served, is the notice, note says the notice has been served by unsolicited.
Which
Let's kindly have a look at the note.
No.
Their habit is not to respond, not to attend. And that is
if notice goes to him, he will come.
Yes.
He may come or he may not come.
Yes.
But service proof has to be with us.
So
that
some service
Tracking report.
Tracking report says it is delivered. Then the service. Call out his name. What is his name? Just call out loudly.
Unique mercantile.
District Sub-Register Khorda.
No. Unique Mercantile India Limited.
Unique mercantile.
Unique Mercantile India Limited.
Unique Mercantile India Limited.
You have not amended the constitution.
Yes, ma'am.
You amended.
Yes. That the notice amended notice, requisite file notice of.
Just the
Unique
Yes.
Unique Mercantile India Private Limited.
What has happened? What are the foundational facts?
Kindly appreciate. And the applicant is a lessee of a government leisure land in Bhubaneswar city for establishment of a hotel at a strategic point.
Lessee of a hotel site.
Of a hotel site in Bhubaneswar. At this point of time, the respondent 3 evinced its interest to join as a joint venture partner to invest its entire fund from his own resources, and complete the project in 42 months from the date of plan sanction. And the plan was sanctioned on 28/6/2014. Plan was sanctioned on 28/6/2014. He took up the work, just started grounding work, did some work, but abandoned the project and left by 2016. So kindly appreciate the plight of the landowner, lessee. It's a government leisure land, my lord. And there is a targeted period in there for completion. And after doing that, some work, left the project, did not respond, remains incommunicado, which compelled the appellant to invoke the termination clause at clause 16.1. That which provides that my place for a moment, that clause. For a moment, I'm snapping.
Now, that virtually amounts to rich court exercise.
That's the background fact. So, admittedly, my lord, the respondent 3 abandoned the project, left it.
Where is the admission?
Pardon? Yes, that I'm showing, my lord. Can you have a look, my lord, at page? One. His reply, his response to the notice of termination. That is on 20th, undated letter, but received by appellant on 20th March 2014. My lords, you kindly have a look at page 43 for a moment. Page 43.
21.
For a moment, page 40. And this is his response. Received by the respondent on 28th 2021, an undated letter. I'll kindly have a look at the relevant paragraph, his admission. Paragraph 7, page 48, my lords. Page 48 is relevant. We are desirous of completing the construction and the project, and therefore request you to withdraw your notice and grant us additional
time of 3 months.
Time of 3 years, considering that so and so. Thereafter, they have also admitted that they have neglected the project and failed to complete in their other reply. Can I have a look, manage?
No, that's all right. That's all right. But you want us to enforce a clause of a private contract.
Yes, my lord.
How? How Writ Court will do it?
My lord's termination clause is there. Clause of termination is there because he failed to comply.
Everything admitted.
Yes, madam.
We can't exercise that.
Madam?
Reader, 1986 Supreme Court.
Yes.
Escorts India Limited versus LIC of India.
My humble prayer for my lord is the district sub-register has no power to make an adjudication as per the recent distribution in K. case, my lord.
But how we can interfere? Because you asked us to enforce a particular clause in a private contract.
No, I'm sorry, my lord. I'm in part, my lord. I don't call upon my lords to enforce that. I only humbly pray my lords to
action of the sub-registrar.
Direct the district sub-registrar to register my delete of cancellation.
No, that is on the basis that the clause of the contract is invocable.
Violated.
No, how can we say that? We cannot say that. Read 86 Supreme Court. No, Justice Ochinaparity's judgment.
Manners may kindly appreciate what will be the fate of the
fate. What he should go elsewhere, not before the recourse.
Well, there is no other really, because I have approached the district sub-registrar for registration only.
No, but even if there is a deed of cancellation,
yes,
how does it affect that party without a declaration?
Pardon, ma'am?
Without a declaration, how does it have any consequence? You are going to unilaterally cancel that.
Unilaterally.
Or even with notice.
He has to go to civil court for a declaration.
Unilateral because he did not respond, did not turn up. I have given him notice to appear before the district sub-registrar to cancel it because you have violated, admitted.
We have recently passed a judgment, of course, of a single judge. You can see this, the sub-registrar cannot entertain this cancellation deed.
Unless both the sides come.
Yes.
Only will can be executed in the, because it's a deed poll, only one party. You can get the will registered.
Yes.
Where two parties are there. Whether your deed is, it has made him a party.
Well, as my lord.
Asking a question.
Bilateral.
It's a bilateral.
It's a bilateral. Admittedly, it's a bilateral.
Correct.
My lord, that is why, as my lord has said, unilateral because he did not respond, even did not respond to the call requesting after the termination. Kindly appreciate. After the termination, invoking the clause of termination, giving him written notice, he responded to the notice, admitted that we have failed to complete the project and time is the essence of the contract that he has said in these specific words. Also, my lord.
That specific performance, he should have approached the civil court, my lord, for specific performance.
Whether sub-registrar has got power to summon the one of the parties to the one of the executants of the deed.
Let's kindly have a look for a moment. Section 22A, Orissa Amendment of the Act, where the other day my lord was rightly pointing out whether the sub-registrar's power under Section 22A of the Orissa Amendment Act of the Act. I am placing where it is specified which documents could be refused to be cancelled. That's the only registered sale deed cannot be cancelled unilaterally. That is there, and all other documents which are provided there in the Section 22A of the Amendment Act of the Act. Nowhere it said that an agreement and that for that purpose joint venture agreement could be also refused. That is not there. That is why Lawrence Single has admitted that.
That if this contention is accepted, tomorrow all our documents will be unilaterally cancelled or consulted. That will be detached.
Now it's not no more unilateral because he has been given notice and he is not responding. And kindly appreciate, man, it's a 150 crore project. The lease land, the appellant is staring at the vulnerable top of cancel determination of a lease for fault of a private individual.
because that is
For a moment.
Section 22, capital A.
My lord.
It imposes a duty on the sub-registrar to refuse to register a document when presented for registration. It is a case of shall.
Yes.
The case of shall not take away the discretion vested in the sub-registrar. Here, in these cases, there is no discretion. That is, kindly listen to us. We have done some work on registration, lot of work on registration law. Power to register is one thing. Mandate not to register is another. This is how Allahabad High Court has said this. The instruments which have been specified under 22A, he has no discretion but to reject registration, refuse registration. In addition to this, it does not say this list is exhaustive. Such sections are not treated by any of the high courts in the country. For example, take Sanjeev Rao and law of registration. He has discussed this aspect of the matter.
My lord, in his endorsement of refusal, he has cited only one reason, that the letter of IGR to the district sub-registrars and registering officers that no sale deed, kindly appreciate, no registered sale deed can be cancelled immediately. That relates to only sale deeds, but in the instant case, it is not a sale deed.
Whether in this interest is conveyed or not.
My point, my lord.
In your JV, joint venture agreement.
Yes, ma'am.
Whether interest is created or not.
No, nothing actually.
Where is that?
Even my lord kindly will
give that agreement.
Pardon,
Show us the document.
That JV.
Yeah, JV.
My lord kindly look at page 18.
Page 18.
Page 18. Page 18. My lord, not even a
whether we have got the Sanjeev Rao's law of registration. Ask the librarian to bring.
Well, even a power of attorney has not even given to him, except that he will invest and start construction and complete it in 42 months.
No, we cannot do all that.
Pardon me?
We will not do that because it will open up a Pandora's box in the sub-registrar's office. Tomorrow, nobody will be safe. If you want any remedy, you should go to the civil court and not before the High Court. Tomorrow he will, on the basis of this judgment, he will register every cancellation deed. But where the citizen should go?
I will submit for my lord's kind appreciation.
My lord, one aspect, my lord, paragraph 24 of the impugned order of the London, impugned judgment of the London single judge. Paragraph 24 at internal page 14. The writ application is allowed to the aforesaid extent. And the impugned order has been set aside and it was remanded before the sub-register.
The London single judge had allowed the writ application, giving discretion to the...
And it was remanded before the sub-register, my lord.
Registration of deed of cancellation of afresh, keeping in mind observations, discussions.
Yes, then
he should not have granted that relief to you. Because it has got enormous mischief potential.
And there are also writ petition filed. A writ appeal is filed, my lord. After this also, how the writ appeal will be maintainable?
Now,
if the writ petition of the appellant has been allowed, then how he is agreed and came before?
He says he could not have amended. He should have been directed to register it. That is his case.
When appeal was filed before the registrar, my lords, against the first refusal order, endorsement of refusal to register by the district sub-registrar for that Bhubaneswar, appeal was carried on section 72 the ADM. And ADM said that the confirmed the endorsement of the district sub-registrar, which was challenged before the London single judge in the writ petition, and the writ petition was direction was given to him to consider.
That relief is in excess of law.
Miles, now the question is Miles kind of precision. Whether the district solicitor can refuse a document to be registered, an instrument to be registered, already a registered document, which doesn't come within the purview of either section 70.
We don't agree with your argument.
Pardon?
The documents which have been enlisted under section 28A, 22A, that section is not exhaustive of all species of documents.
But
we do not agree with that. We will make it clear also.
But the kindly appreciate, I humbly submit. That section has been introduced to the statute book only to give, solely to give protection to such class of people who have no other remedy.
No. They have not said. Otherwise, how sections will read? The registering authority shall refuse to register these documents and no other documents. There are such texts available.
In that case, my lord, you can find any registered document. If the other party doesn't cooperate, fails to cooperate.
Then civil court. The only way is civil court.
So in that case, my lords, in this case, since the respondent number 3 has already been called upon to appear.
No, not to
appear.
No. Even this, we wanted to set aside this judgment, but nobody challenging before us. This judgment will breed a lot of mischief, public mischief. All because they will cite this judgment and they will say, we will register cancellation.
May I will pay my lord to kindly appreciate the other side of the picture. The appellants.
Sir, you are a very persuasive lawyer, but we are not persuaded. We are not persuaded because consequences we are just contemplating.
Because of non-cooperation and
for that civil court, you should get a decree, then you should get it. But anyway, this order is made now. So we will, you take whatever benefit you want to take.
So my lords, in that case, I bow down. I know I am not able to convince my lords on
we feel very bad that we are not being convinced. We are not able to get convinced because the mischief potential of this judgment is enormous. No citizen will be safe, I tell you. The kind of officers we have,
my lord,
they will register every cancellation deed, and tomorrow your sale deed also may be cancelled.
Cancellation deed invoking a clause of cancellation. Kindly appreciate.
Can the sub-registrar say on the without the party? Can he say that your deed it is a Procedural is there?
Yes.
Yeah.
Parties conduct, my lords have seen. Parties
no, we don't take it.
They did not bother to. And so one more prayer, kindly bear with me.
No, we have spent a lot.
No, just a minute, my lords.
Yes.
In that case, my lords may kindly give the liberty to the appellant to move to civil court under section 31 of the specific.
Why civil court? You go unnecessarily. Why do you go to civil court?
Why, sir?
No matter is remanded. You go before the sub-registrar with this order. In the event he decides against you, then civil court.
Well, yeah, this is the second time he has refused. This is the second time he has refused.
No, that order is that is
last endorsement he refused. That was challenged in section 72 before the ATM. He confirmed it. Then writ appeal was filed. Learned Singler's partly allowed the
directing.
Directed him that you consider. Then he refused. This is the second refusal.
Where is that
refusal?
Second refusal. Man, kindly have a look at. What's annex, sir? Kindly have a look at. Annex, sir.
That I'm not having.
Page 90, page 90. Page 90.
Move reference.
Page 90, annex.
This is dated?
Well, this is dated
7th
March. 7th March. Well,
this is subsequent to the learned single judge's order.
Subsequent to the order of the learned single judge.
But you challenge, you are having taken benefit of the single judge's order. You went there. And thereafter he passed this order. Why? How can you put this order in appeal? You have drawn benefit, you have drawn milk from the order of the learned single judge. How can you now turn around and put a challenge to this order?
In any case, my lords, the order is already challenged before my lords, and
I was under the impression this order has been passed, and therefore now you are before the court. You have taken the benefit of this order.
Now, as I humbly submit, my lords may kindly devise a way of protection for the women entrepreneur. More than 100 crores of property is lying idle for last 11 to 10 years, more than 10 years. From 2014.
Then in 2014 itself, you should have filed the suit.
We invoked, she invoked the termination clause, gave notice, and now even from here also after getting notice, not responding, this is...
This intra-court appeal seeks to call, kindly be seated, seeks to call in question a learned single judge's order dated 31/1/2024, entered in appellant's WPC number 32589 of 2023, whereby some relief was conferred on the appellant in the following fashion.
Fortunately to us, religion was opportunity given by my lords, where notice issued to him did not respond deliberately. That is my humble prayer. What else?
19, 20, 21, 22, 23 paragraphs. The above order being in the nature of remand, the sub-registrar, while endorsement dated 7/3/2024, again refused to register the joint venture agreement.
Register the deed of cancellation of them.
Refused to register
the deed of
cancellation of
the registered JVA dated 11/1/2013.
Unilateral. No. Registered JVA.
Registered joint venture agreement.
Registered JVA. Registered JVA. Registered the registered.
Deed of cancellation.
Cancellation of registered document.
Cancellation of the
registered document.
Cancellation of the deed of registered JVA dated 11/1/2013.
Dated 11/1.
But that is unilateral. On that ground, it was rejected.
First, learned counsel for the appellant very passionately argues that Section 22 capital A of the Registration Act 1908, as amended by the state legislature via Act number 1 of 2014, dated 22 February 2014, enlists specific instruments, stroke documents, which alone can be refused to be registered, and that the instrument now presented for registration not being one of them, the sub-registrar has no discretion to disobey the legislative mandate couched in Section 22A statement. First off, learned AGA appearing for the official respondent, kindly be seated.
Sir, please sit.
Kindly be seated. Kindly be seated. If you want to rectify us, you can rectify by sitting. You are a senior member of the.
Submissions for my lord. But the only, I am sorry to interrupt. The only prayer, my lord, is there must be some way out for the appellant.
We will say that we will send you to the suit.
Suit cannot, that's the problem. Suit cannot go for suit under section 31 of the Specific Relief Act. Again, she has to go back to the district sub registrar for the third time and on his report. Yes, sir, that's 7.2, section 7.2. For a moment, can I have a look for 7?
No. Suit lies under Dholabai. 69 Supreme Court page 78.
No, my lords, there is a specific clause provided.
That has been interpreted by Dholabai. When suit is excluded, what is meant by that has been discussed by the apex court.
There a problem will arise, limitations.
No, that you see, we can't help. For every suit, that's not a problem. That's a legislative condition.
May I pray, could my lords be pleased to give liberty and to the appellant to file a suit before the this is civil court under section 31 of.
Will not say anything else. Disputes of the kind should be worked out in civil suits. Again, suits will be subject to limitations, so many things. Okay.
When subject to limitation once.
No, you will not allow us to write. We will write the judgment in the chamber. Dismissed. Reasons to follow. Next.
Item 32, date appeal 2002 of 2025.
My lord, item number 32, that is the read petition. As I have gone to the through the facts, it is intrinsically connected with two other read petitions which have been disposed of, and judgment also speaks about those two at the instance of the petitioner only. Two separate read petition is also connected with this.
Record liberty. We'll record liberty to go to the suit.
I'll be demobilized. My lords, at least 100 more than 100 for property will be saved for no fault of the appellant. That is what I want to beg the day, my lord.
Not true. Yes.
Paragraph ground number D, your lordship may see at page number 20, running page number 20, our appel memo. Ground number D, we have mentioned that two connected read petition, WPC number 7517 by 2017 and WPC number 188 by
9 of
2019. Those two read petition records are very essential for your lordship's consideration.
No, everything has been clarified, but
not clarified.
Settle the issue. Now, single judge has clarified everything. My lord, I'm not getting pension.
No.
Sir, my lord, last 3 days I'm approaching your lordship.
No.
Look at, I've prepared small date chart. Can make your lordship understand what is the position of a litigant. I've been considered from 1985, my lord. 97 before lordship, before the judicial authority, my lord.
No, those
it was decided in 2015. Travel categorical directed by seniority will be with effect from the date of admitted junior. My lord, this is a limited submission for lordship, my lord.
Also, paragraph 9, your lordship, paragraph 9.
Today morning, I traveled from Bangalore to Bhubaneswar in a flight. And the air hostess was very kind to me. She gave the earplugs. So there was no disturbance at all.
That's my problem.
We are reading the order. No? Your merit list is of the year 1988.
Yes, ma'am. 88. Ma'am.
Date is?
Date is 18/4/1988. Merit list prepared.
1 second.
Let me take one of the
18/4/1988 is the merit list.
prepared, madam.
Appointment is dated.
Then, my lord, the admitted less meritorious candidates were appointed. But we could not be. Then, my lord, appointment is 97. Appointment. I'm giving date chart.
97 January 1st to 31st of December.
Date is not stated since appointment to give. Other candidates were given appointment 97.
Which date?
Date is not there. In fact, other date is not there. 98. I was offer appointment, but that was not given effect to.
1 second. You were appointed in 1988.
I was given offer of appointment in 1998.
What it says? Given offer.
Given offer. In terms of direction the traveler. Then then another person, the admitted less meritorious candidate, but some subjective termination, they approve the traveler. Then traveler said that both you accommodate all the candidates. Then they approach the High Court. High Court confirmed it. Then they approach the Supreme Court.
No. When did you get entry?
After Supreme Court judgment, 2015, man.
For the first time in 2015.
First time you went to tribunal when?
Tribunal went to 97. That I've given a dead chart also clarify everything, 2 pages.
So that will be over burden on us. Only relevant things are.
Yes, I'm sorry, man. Have I also predicated by
1997, you went to the tribunal.
I approached the tribunal.
And your prayer was, what was the prayer?
That I should be given appointment above the person those are admittedly less meritorious than me.
It was a seniority.
Madam, there was a merit list. Let's look at it. Just a merit list.
No, we want to know, since we have some deficiency in service law, very humbly we are telling you. The merit list was published on 18/4/1988. When was it sent to the government?
That is, materials are not available with me, but 97 others were given appointment. Then I approached the tribunal. That less meritorious were appointed, I was not given appointment.
Slowly we will go one by one.
Yes, ma'am.
Clarity is very important.
Yes, ma'am.
18/4/1988 is the merit list.
Prepared and published by the PSC.
All right. Who others were appointed in which year?
97. 17 persons were appointed in the year 1997.
17 or 70? 70.
70. 7, I'm sorry.
70?
Yes, ma'am.
From the same merit list?
From the same merit list.
You were ignored.
I was ignored. Though I am more meritorious than they.
Okay.
They were appointed in the year?
1997, madam.
You were denied.
Denied. I approached the tribunal. Tribunal on 8/1/1998.
Your application OA number or
OA number is 1973 of 90. I'm sorry, madam. OA number is
1973 of 1990.
Yes, that is a similar matter. My case number is I'm giving it.
1973 of
2095, madam.
But this is
95.
This is not.
No, I'm sorry. 95, another case exactly.
Your case is what?
OA number is must be in the record.
1709 of 1997.
107. Yes,
That is para 4.
OA number 1709
of 1997.
What was the prayer there? Prayer was? All right. Can you tell when he was appointed? On which date you came to be appointed?
I was subsequently, after the judgment of the tribunal,
We are asking.
98.
Pull down some date from the calendar and tell the date. On which date your client came to be appointed?
I was, my lord, practically in 2015. That is
practically, impractically. That will tell us the date on which he has been appointed.
115.
So that there is one judgment which is in your favor that may come to your aid.
Well, 2/1/2015, after the judgment of the apex court.
2-1 or 3-1?
2/1/2015.
Who went to the apex court?
Government.
Government went to the apex court.
Government approached this one.
In SLP number?
In SLP number, my lord.
12730 of
Yes, sir.
2011.
Yes, but 12730 of 2011.
SLP number?
12730 of 2011.
12730 of 2011.
SLP was decided on which date?
SLP
11/4/2014 on the ground of delay. It was dismissed.
What was challenged in SLP? What was the order that was challenged in SLP?
I was not a party, my lord, because they said
You are not a party.
I was not a party.
You are citing the SLP now.
No, that the state approached the High Court, state approached the Supreme Court, but I was state
Against what order?
Which order?
against the order of the High Court.
It must be order of the High Court.
Yes, yes.
Yes, but you cannot go in SLP.
Let's repeat. That's what I'm trying to canvass your lordship.
No, we want to know. We are asking certain facts so that we may do justice to your client.
Right, madam. I want to clarify the facts because two for appointment.
We not clarify anything.
All right.
We are now telling we are proficient in evidence in service law. Earlier we were very.
I will get it pleasure to appear before lordship.
We do not
The matter you. That
We
time.
do not know that. What was the judgment challenged in the SLP?
The judgment of the High Court, my lord, in
Because by that time, L. Chandrakumar had already come.
Paragraph
L.
6.
Chandrakumar said you should not come to Supreme Court. You should go to High Court.
they have approached the High Court.
That we were asking you.
Paragraph 6.
What was
Your
the
Lordship.
judgment?
Paragraph 6.
6 of the impugned order.
Yes.
Nandas,
Aratinanda.
Arthinandas
Has to be applied to me. That's a limited intent.
try to para 4.
Para 4. The facts of the case stated in brief, the petitioner initially filed OA number so and so, praying his appointment as junior assistant, questioning the preparation of selection list pursuant to the recruitment held by the OPSC on 28 June 1987 for the purpose of junior assistant in Odisha Secretariat Service. Said original application filed by the petitioner was disposed of in terms of the principles and directions issued in similar way filed by another applicant, namely Arati Nanda, in original application number 1973 of 1995. Order dated 8/1/1998 passed in OA number 1709 of 1997 reads as under. Her principle has already been decided in the decision in so and so Aratinanda versus State of Orissa decided on 12/8/1996. I direct the respondent to apply the principle to the facts of this case and consider the question of appointment of the applicant accordingly. Original application is allowed. The operative portion of the case of the Aratinanda speaks as thus. However, challenging the decision in Aratinanda, state preferred writ appeal, a writ petition, and then approached the Honorable Supreme Court. So and so on.
So, in Aratinanda,
yes,
court said you appoint Arati to a vacancy then available.
Yes.
For all practical purposes, that will be the date of appointment. Okay. that order was duplicated in his way.
Yes.
All right. The Arthinanda was taken in repetition was preferred. Therefore, I say that that number is not available.
Para 6 is saying
So there was a writ petition order by the coordinate bench. That order we have to see. That order came to be affirmed by the apex court, saying what has been decided by Arathinanda is correct. That's what apex court said. On the basis of that, your petition came to be allowed. OA 1709 of 1997.
Decided 90.
That came to be allowed. Now, pursuant to that, you came to be appointed on 2/1/2015. Now, if you are appointed in 2015, now you want seniority.
Only my lord, I have retired. Only qualifying. Let's say, look at the other thing of the order, paragraph 5. Only can lords, you can clarify.
It is reproduced, no?
Reproduced. Page 30. In such circumstances, the direction government to appoint as junior clerk, have the responding direction appoint if a vacancy available, if no vacancy available, the same has to be created. To give appointment to the applicant, he will have to wait for the same. No reason, no sooner. The applicant is given appointment, he will be gate or position in the merit list above the person appointed below her in the merit list. For all purposes, that would be the date of her appointment, but she will not be entitled to any salary or other benefit of service, except that period would be considered for experience and qualified service for purpose of pension. That is what I am asking. I have been retired 2023. I say my appointment should be dead back in terms of the tribunal judgment, and it should be qualifying, notional pay fixation in terms of the Arathinanda. And you have approached the High Court, Supreme Court, I have been suffering. And 98 offer appointment was also given to me, pursuant the tribunal judgment, which could not be given effect to, because the persons who were terminated, they approached the tribunal and the High Court. And my order was never challenged before any court. Their termination was challenged, again it was before the High Court, again before the apex court, my lord. So my order is never challenged. This order was never challenged before any other court. Those who are terminated, they challenged. Tribunal said accommodate them. Then those who were admittedly less meritorious, they challenged. Court said that you are accommodated them. Then they approach, then government approach High Court, then approach the Supreme Court. Thereafter they give me appointment. Though they have already offered given an appointment in 98 for such a tribunal judgment. I am not getting appointment, no one seniority, my lord, only qualifying service and gave pension benefits. That much I can advance. And the order of 97, other thing also may be complied with. That is the single, honorable single judge judgment, my lord. That I want to bring to lordship notice. Perhaps I am not clear. And my apologies, my grandfather and father is hard of hearing. So I have been, by many judges has feel bad to that manner. My apologies, I had of hearing. That's why I used to speak in loud words.
No, but your being hard of hearing is one thing. Why you extend that presumption to us also?
So it's
Mr.
Only one ground we have urged before your lordship.
He says
no, whatever. Only on one ground we have come before your lordship. Long settled position may not be allowed to be unsettled.
Don't unsettle anybody. He is saying, my client has retired now. Don't unsettle anybody.
Don't.
You give us some ranking.
Then I will give to your lord. Because on that ground we have only that ground.
Retire.
It's a long journey, long settled position.
But I have duly selected through OPSC manner. Less meritorious candidates were appointed. I was ignored.
Take down. This intra-court appeal by the state and its functionaries seeks to call in question a learned single judge's order dated 2 January 2025, whereby respondent employees apostrophes WPC number 20425 of 2020, having been favored, the following relief has been conferred on her or him.
Him.
On him. Can you be seated? to next. 15, 16. How many days of delay?
That they have condoned it. They have paid money for condo.
We have paid.
That's it.
The cost
That's condo.
we have paid. Lordship have already condoned it.
Yes. Next. Learned after service of notice, the respondent employee having entered appearance through his counsel vehemently resists the appeal, making submission in justification of the impugned order and the reasons on which it has been structured. First, the senior advocate appealing for the said employee submits that the relief that was accorded to his client was in terms of Nanda's. Arati Nanda's case decided by the tribunal, Orissa Administrative Tribunal in OA number
1709 up to the 997.
No, it's your way, na?
Yes, sir. Arjun 1973 up to the 1995.
1973 of 1995. Disposed of on?
Disposed of on, my lord.
Fairly visited, sir.
Sir.
You're all seniors, sir. Why do you stand?
Is 8198 as
8198.
No, that was my order.
No, it was your order, na?
But it was reported in 1997, volume 2, 80 Odisha, 48, Arati Nanda versus State of Person. That is the... My lord.
How can we write it if you say so fast?
That is para 4. Para 4, you lord.
Decided on 12/8/1990.
Yes, 12/8/1990. I'm so grateful. So grateful, your lord.
12/8/1990.
12/8/1996.
First, Nanda's decision having been put in challenge before the coordinate bench, came to be affirmed. And further challenge by the state in SLP number 12730 of 2011 met the same fate on 11/4/2014. First, lastly, he adds that there being no challenge whatsoever to the tribunal's order in his client's OA number 1709 of 1997, made on 8/1/1998, finality has been attached, and therefore, on the principle of parity, whatever benefit has been accorded to Nanda, Arati Nanda, as of necessity has to be extended. His principle. First. Next paragraph. Having heard learned counsel for the appellants and having perused the appeal papers, we decline indulgence in the matter for the following reasons. A. In the OPSC selection process, a merit cum select list came to be prepared and published on 18/4/1988, wherein respondent's name figured at serial number 787. And Nanda's was what?
Nanda is senior than me. He's senior than.
That is a bit below the Arati Nanda
name is there.
Name. First one. In Arati Nanda's case, The tribunal observed as actor. The paragraph 5 of the impugned rights is the reproduction. As I can see. Next slide. Next paragraph. As is forthcoming from the record of the case, comma, the relief granted to Arati Nanda has been extended to the respondent employee in OA number 1709 of 1997, disposed of by order dated 8/1/99. First term. Since the reasoning and the relief in Arati Nanda has attained finality at the hands of highest court of the country, and the same being the substratum of the order of the impugned order, comma, learned counsel for the respondent employee is justified in seeking dismissal of this appeal on the principle of parity. More particularly, when no challenge whatsoever was laid to his client's to the order of the tribunal made in his client's OA number 1709 of 1997. First off. Next one. In Arati Nanda's case, specifically the appointment and placement in the seniority list are spoken of at para 10 of tribunal's order in her OA number
Her OA number is just
what is her OA number?
1973 of 1990.
1973 of 1990. What is written? Disposed of on first term. She was accorded seniority at serial number 1082, and the respondent hearing, having been appointed on 2/1/2015, that is after the disposal of the case in SLP number 12730 of 2011, sorry, this is 2011, na? 2011, yes. On 11/4/2014, yes. What you have written now? Was given ranking 10. Was given rank, that means similar to your ranking is 787. That is inside junior to Arati.
1080 was done. Arati is senior.
No,
but the person who is admitted junior, I was better party before the High Court. He is admittedly junior than me.
And 787. First off, the simple arithmetics would show that the respondent hearing is obviously senior to Arati Nanda. First off. Therefore, learned single judge has rightly structured the order, impugned order, accordingly, regardless of the date of appointment. First one. Absolutely no explanation is forthcoming from the side of appellant state as to why the merit list of 18/4/1988 was not finalized for more than a decade. First off, ordinarily, select list of the kind has to be operated normatively within 1 year. First off, that has not happened here. First off, thus there is a culpability attributable to the appellant state.
Because of the continued litigations, my lord.
They all you lost the litigations. First off. The contention of Mr. Panda that operation of the select list was delayed because of an avalanche of litigations hardly constitutes an explanation, in as much as in all those litigations, state is the loser. First off. Next paragraph. The last contention of Mr. Panda that seniority list, once prepared and operated, cannot be lightly interfered in as much as that would result into displacement of others, which would not augur well to the administration, again is difficult to agree with. First off, such a displacement argument has no scope in as much as the respondent employee has already retired from service
to 2023.
You don't give the date at all. Way back in the year 2023. And
31/5/2023.
And giving a notional date of placement in the seniority list in the circumstances would not affect anyone. First off, we, by way of abundant caution, make it clear that the relief granted by the learned single judge by virtue of impugned order shall not be displacing anyone's placement in the seniority list. First, in the above circumstances, this appeal fails. With a direction to the appellants to give effect to the impugned order of the learned single judge within an outer limit of 8 weeks, since the respondent employee has already retired from service. Courts reluctantly made easy. Grateful. Okay.
Yeah, rise little early, your lordship had exposed that your lordship is to rise little early.
Number 4. I'm the borrower. I'm the more suffering in the matter. Illegally, my house has been auctioned. And
when it was auctioned?
Item 34 is the similar matter. Out of 4, your lordship already disposed of 3 matters. I have in the copy also. Last occasion, my friend is here.
Is it true?
That is Union of India matter, 34.
Here, I am the petitioner, my lord. I have a very good important lot of totally tally with the not similar to the judgment they have produced, my lord.
Similar to the means name will be different, date will be different, judges will be different. Whether substance is same or not?
Substantial MSc matter, my lord. The opposite party, my lord senior. The second time she has engaged as the work inspector, my lord.
Second time?
Again, he is joined as a work mystery, my lord. Thereafter,
You tell it in Oriya, so that it becomes clear to my
Mystery.
brother.
Work mystery, my lord.
Work mystery.
My lord.
With what qualification? Unskilled. Unskilled. So his initial engagement was work mystery.
My lord.
Then?
Thereafter, the first RRP, recruitment board, second time. We have calculated our MSCP after deducting the training period.
That we have already decided, na? But this is a post-appointment training. Apex Court said in Rajasthan case, post-appointment training, from the date of appointment, service has to be counted. If it is pre-appointment training, then case would have been. Yes, we have already decided that.
I have given that copy along with the memo. And basing on the Supreme Court decision also, your lordship already 3 cases your lordship decided. Out of 4
cases.
Out of 4, my lord, 3
are decided.
Decided. There is no difference in comma full stop also. And my friend is taking this free, my lord.
That was Satyabrata. Union of India versus Satyabrata Drupal.
Yes, yes, my lord. And Siddha Gopal, 3 cases your lordship may kindly see. Thereafter, my lord.
What are those? What is your WPC?
Item 36. I'm retiring next month. I'm retiring next month. I'm retiring. I don't have a house to stay. That's
after retirement, you don't have house.
My house is an auction, and it is the DRT.
If you do not, you have given the mortgage of the house, and mortgage is
it is on DRT. They have fraudulently auctioned the matter.
In this matter, essay is pending.
Essay is pending.
The auction.
Select the essay.
You have to dispose of within a stipulated time period.
Can go to the
only that is the only.
Can go to the petition auction. Tomorrow it is the essay is to be heard. One more date is there.
Essay tomorrow.
Tomorrow.
We'll direct them to tomorrow here and dispose of the matter.
My lords.
All right,
my lords.
The short grievance of the petitioner borrower is against the coercive action of recovery constituted under the provisions of the SARFAESI Act 2002. First, Learned Panel Counsel appearing for the bank submits that petitioner's essay number
137/2023
is pending, wherein grievance of the kind can be worked out before the ERT under section 17 of the Act, and therefore interference of this court is unwarranted. First of all, we agree. Next paragraph. We also agree with the submission of Learned Counsel appearing for the petitioner.
I'm not the petitioner. I'm the OP number 4. I'm the borrower. Petitioner is the auction purchaser.
Petitioner. I know. You are auction buyer.
Okay. I am the borrower.
Your essay is pending.
My essay is pending.
Both the sides unanimously submit that borrower's essay number so and so is pending before the ERT under section 17 of the 2002 Act, and a direction be issued to the tribunal to decide the same on a war footing, regard being had to the imminent retirement from service of a petitioner.
OP number 4.
OP number
4.
OP number 4.
The Duni.
4. First one. Right to speedy justice being a constitutional guarantee in the light of a catena of decisions of the Apex Court, a direction as sought for can be issued in this matter. First, in the above circumstances, petition is disposed of. requesting the presiding officer, learned presiding officer of the DRT Cuttack to hear and dispose of the said essay on a war footing, keeping in view the imminent superannuation of service of OP number 4. First of all contentions kept open.
Pardon my lord, I don't have.
And that remains up to them. The grievance that is sought to be worked out at the hands of this court, we permit the petitioner to make an appropriate application in the pending essay itself within a period of 10 days. And the tribunal to consider it on merits.
Pardon my lord, item number 35. The verification process of the trade union has been stayed here last.